The President, please be seated. The court is now in session. During this morning session as scheduled, the trial chamber is going to hear the testimony of the expert, Justice Richard Goldstone, in relation to the character of the accused. This testimony is going to be heard through video conference, and we're going to hear his expertise and complete his testimony through such a video conference. And we're going to take the whole morning session for the purpose of this testimony. Before we start our proceedings, the greffier is now instructed to report the attendance of the parties of the proceedings. The greffier, Mr. President, the parties to the proceedings today are all present. The expert who is going to testify in the moment, Justice Richard Goldstone, is ready in the United States, and Mr. Raul Jena is also available. These two witnesses will be taken an oath through the remote participation. The President, Mr. Alan Koyana, you proceed. Could you please be brief, because we want to make sure that we want to hear the expert as scheduled, and we're going to hear him just one whole morning.
Bonjour, Monsieur le Président, Madame, Messieurs les juges.
Good morning, Mr. President, distinguished members of the court. I'll be very brief. Simply to recall that 2 weeks ago, on 31 August, I spoke to this chamber and specifically asked whether I could, as quickly as possible, receive the written motivation of your 27 August finding. It was very difficult for us to explain to our clients the decision that was made. It's been 2 weeks now. We don't have a written decision, and I believe I speak on behalf of all counsel for civil parties, simply to ask whether you might give counsel for civil parties when you intend to give us a written version of the decision. Thank you.
The President, the trial chamber has not taken it for granted, and we have paid great attention to the decision, and we already rendered our decision in oral decision, and that the recent written decision will be made in due course. And due to the commitment in the last plenary session that our judges were supposed to take part to debate in the proposed amendments, and it was for the smooth operation of the court. If there is a case file 003, If it should be, then the judges had to meet to discuss this matter in advance. And at the same time, we do not forget to make a decision on the matter, and the decision has been translating, and we believe that tomorrow we will have verified all the three versions of the decision and will be included into the case file in due course. So it is the obligation of the court to produce the written reasoned decision accordingly. The AV unit is now instructed to link the video conference to the expert, please. Good morning, Mr. Expert. Could you please tell the court your full name?
Mr. President, my names are Richard Joseph Goldstone.
The President, thank you. Justice Richard Goldstone, how old are you this year?
I'm 70 years old.
The President, question, where do you live now?
My permanent home is in Johannesburg, South Africa, but I'm presently living for 4.5 months in New York, where I'm teaching at Fordham Law School.
The President, Justice Richard Goldstone, what is your occupation?
My occupation is now a visiting professor, and I'm a retired justice of the Constitutional Court.
The President, what religion are you a follower of?
I'm a follower of the Hebrew religion.
The President, according to the report of the greffiers of the trial chamber, indicates that you have no affiliation or relationship with the parties to the proceeding. Is that correct?
That is correct, Mr. President.
The President, Natasha, could you please coordinate with Justice Richard Goldstone so that he can take an oath before the chamber?
Good morning, Justice Goldstone. Please repeat after me.
Morning.
I solemnly declare that I will assist the trial chamber honestly, confidentially, and to the best of my ability.
I solemnly declare that I will assist the trial chamber honestly, confidentially, and to the best of my ability.
The President, I would like to give the floor to Judge Sylvia Cartwright to proceed with some questions.
Thank you, Mr. President. Good morning, Justice Goldstone. I will first ask you some questions that explains to the court and the people of Cambodia what your qualifications to give this testimony are. Can you hear me clearly?
Yes, thank you, Your Honour. Good morning.
As we have already heard, you have been a judge in South Africa, and in 1980, as I understand it, you were made a judge of the Transvaal Supreme Court, later a judge of the Appellate Division of the Supreme Court, and from 1994 until 2003, you were a justice of the Constitutional Court of South Africa. Is that all correct?
That is all correct, Your Honour.
Thank you. From 1993 until 2007, you were also Chancellor of the University of Witwatersrand in Johannesburg, and as we have already heard, you are a visiting professor of law currently at Fordham Law School in the United States of America. Is that correct?
That is also correct.
You've also been a visiting professor of law at Harvard Law School, NYU Law School, and Georgetown Law School. Is that correct too?
That's correct, Your Honour.
Well, you've had a very distinguished judicial career, but there are other parts to your career that are of particular interest to this court insofar as it relates to the matters that we would like to hear about from you today. You have been a member of boards broadly concerned with human rights, justice and reconciliation. Is that right?
That is correct.
And this includes chairing the advisory boards for the Institute for Historical Justice and Reconciliation and the Brandeis University Center for Ethics, Justice and Public Life. I believe that you are also co-chair of the Human Rights Institute of the International Bar Association, and that you have chaired a United Nations committee to advise the UN on appropriate steps to preserve the archives and legacy of the International Criminal Tribunals for the former Yugoslavia and for Rwanda. Is that all correct too?
That is all correct, Your Honour.
Thank you. Most recently, you have a very challenging appointment to lead the United Nations fact-finding mission on Gaza, which was established by the President of the United Nations Human Rights Council. That correct as well?
That is also correct, Your Honour.
Thank you. From the 15th of August 1994 until September of 1996, I believe you served as the Chief Prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. So you've had extensive experience in international criminal tribunals. Is that the case?
Correct, Your Honour. Just one slight correction. The tribunal began at the end of November 1994. So my term of office as prosecutor later than in respect of the former Yugoslavia tribunal.
Thank you. Can I just pause here for a moment and inquire about the sound interruptions from Justice Goldstone's end? the IT unit able to assist here? Just to inform you, Justice Goldstone, we're getting some interruptions. I'm not sure if you're getting them from this end or not. We're just pausing while a bit of a discussion goes on concerning that. Thank you. I've been told, Justice Goldstone, that we can keep going, and the IT people are working to improve the link. Now, in 1998, you chaired a high-level group of international experts that met in Valencia, Spain, and drafted a declaration of human duties and responsibilities. That was done for the Director General of UNESCO. Is that the case?
That is correct.
And from late 1999 until December 2001, you chaired the International Independent Inquiry on Kosovo. And in December of 2001, you were appointed as the co-chair of the International Task Force on Terrorism established by the IBA, the International Bar Association. Is that correct as well?
That is correct, Your Honour.
Thank you. You are a director of the American Arbitration Association, and from 1999 to 2003, you also served as a member of the International Group of Advisors of the International Committee of the Red Cross. From 1985 until 2000, you were national president of the National Institute of Crime Prevention and the Rehabilitation of Offenders. Is that correct as well?
That is all correct, Your Honour.
Thank you. Not surprisingly, you have received many awards and honours for your work in the fields of law and human rights, and I hope you will forgive me if I don't list those today. You're also the author of books, including For Humanity, Reflections of a War Crimes Investigator, 2001 Yale University Press, and the co-author of International Justice Institutions, The Architecture of International Justice at Home and Abroad, published just last year. Now, is there anything that you would like to add that you consider is relevant to the testimony that you are being asked to give today, which concerns the importance of acknowledging guilt in an international criminal tribunal?
Honor, all I would add is I had in investigating serious violations of human rights and violence in my home country, South Africa, between 1991 and 1994, really laid the foundation for the truth that followed in 1995.
Yes, we got a bit of an interruption then, but I gathered you said that that work laid the foundation for the Truth and Reconciliation Commission, which followed in 1995. Was that what you said to us?
Correct. Yes.
Thank you. Now, just to lay the groundwork for you before I let you have a chance to speak, I'm going to set out the situation here. The accused in this trial, Kaing Guek Eav, is known more commonly as Duch, which was the name he assumed before the Khmer Rouge period and which was used by him during that period and down to today. So it may be easier to use that name, Duch. The accused has admitted his culpability in relation to the charges he faces, which are, of course, extremely serious ones. He's admitted his culpability broadly, while on occasions stating that he does not accept particular facts or particular individualized allegations. In addition to that, he has cooperated at all phases of the trial, and as the trial is operating in the civil law system, that includes an extensive judicial investigation, followed by the trial, which is now nearing its end. In addition, from time to time, he has helped the court in clarifying factual issues. And I think it's fair to say that one of his two counsel, Maître François Roux, has said that if this were the common law system, he would have pleaded guilty to certain of the offences. I'm sure Maître Roux will clarify that in due course. He has admitted in writing, or not opposed, a very large number of the factual allegations made against him, which factual allegations are taken from the case file and the indictment. So that is, very briefly, and I'm sure the defence will want to expand on that significantly, the measure of the cooperation of Duch in this trial. It needs to be said, of course, that I'm sure the prosecution, but certainly the victims who are in this system are called civil parties, as you will be well aware, do not always accept that he has been cooperative or that he has been entirely truthful. But I think that that gives you a broad outline of the current situation as it pertains to this accused. So we would be very grateful to hear from you on what you can say in relation to this admission of responsibility in terms of international justice, and what importance that his attitude and cooperation might make in reconciliation in the Royal Kingdom of Cambodia. Does that give you sufficient background to provide a basis for your comments?
Yes, it certainly does, Your Honour. Thank you very much.
Well, Justice Goldstone, I'll now give you a chance to speak, and we'd be very grateful to hear from you now. Thank you.
Thank you very much. Well, if I might start with a general statement that in my experience in the South African courts in which I've sat, and also in the international courts for the former Yugoslavia and Rwanda, I would suggest that there are three important aspects that must be taken into account in regard to sentencing. The first is clearly the nature of the crimes, and as you have stated, Your Honour, the crimes here are of a extremely serious nature. The second is the interests of the victims, and that obviously must be reflected in any sentence by a criminal court. And thirdly, the more general interests of society. And of course, the difficulty for sentencing, for a sentencing court, is that these three factors often come into conflict with each other, and one has to find some proportionality between the three of them. The interest of society, I would suggest, dictate that a due attention must be given to the importance of an open and sincere admission of guilt, and especially so if it's accompanied by genuine apology to the victims and expressions of remorse. If I might turn particularly, because I understand that is really the main point of my evidence, is the effect and importance of an admission of guilt, to use the common law experience, but I don't think in this regard that there's any difference in principle from a moral or jurisprudential point of view between common law and civil law systems. I would submit that there are three important aspects of an acceptance of guilt and an apology. The first, obviously, is the importance for the victims. It's certainly been my experience, particularly in South Africa, that victims know what happened to them. They don't need any criminal courts to establish for them what they personally experienced. But what is important, and what justice and what courts or Truth and Reconciliation Commission for that matter may provide to victims, is a public acknowledgement from an official source, and especially it's important that it's a court, that there is this public acknowledgement of what happened to them. It's again been my experience, and it's difficult to generalize, but in many cases, victims have been able to begin their closure and their healing in consequence of a public acknowledgement of what happened. It's important for what they know happened to them to have this public acknowledgement. The second, and from a societal point of view, very important advantage and a benefit from an admission of guilt and an acceptance of guilt is that it is crucial to put a stop to fabricated denials that usually accompany all serious human rights violations. If I might give one example from my own experience in the Yugoslavia Tribunal, and I hope it will be of assistance and not irrelevant, was the case of a man called Erdemovic. Erdemovic was a member of the Bosnian Serb army, and he, acting under what the tribunal for the former Yugoslavia accepted, both the trial chamber and the appeals chamber, accepted was huge duress. He joined a firing squad that shot and killed scores of innocent Bosnian men and boys outside the city of Srebrenica in 1995. And Erdemovic, some time later, decided that he wanted to confess guilt, and he did it, strangely enough, in the first instance to a television company, to an American television company. A team interviewed him in Serbia, and he eventually was, to my surprise, because I requested an order from the trial chamber against Serbia to have him transferred to The Hague. He was indeed, and he was charged with serious crimes against humanity, murder, and other serious charges within the jurisdiction of the Yugoslavia Tribunal. He pleaded guilty, he made a full confession, he apologized to the victims, and he was treated fairly leniently by the court. If my memory serves me correctly, the ultimate sentence on appeal was in the vicinity of 7 years, and this was after an admission that he had shot and killed at least 70 people. According to his evidence, he lost count after he got to 70. Now, what was important was that before his evidence was given, and before his admission and confession, the Bosnian Serb government in Palais and the Bosnian Serb army denied the massacre in Srebrenica happened. They said this was a fabrication on the part of some Western nations to put guilt incorrectly and unfairly on the Bosnian Serb army. And they said that if indeed, and Demovic incidentally was able to pinpoint the mass grave where his victims were buried. And the Bosnian Serb spokesperson made a statement to the effect that if there was a mass grave where he pointed it out, which they denied, they said it would if the bodies were exhumed. It would demonstrate that the bodies buried in that grave were killed on the battlefield during armed insurrection many years before. Well, the mass grave was exhumed at my request by expert forensic people, and it was proven beyond any question that the people in question had been killed by a single bullet wound to the back of the head, that their arms had been tied behind their backs, not the situation that would arise where people are killed in the heat of battle. It was also established that they died at or about the time of the massacre at Srebrenica. The effect of Demovic's evidence and the mass grave exhumation and other corroboration really put an end to the denial by the Bosnian Serbs of what happened in Srebrenica. And of course it was important to the victims, firstly, to have the acknowledgement of what happened, but it was also important to help many of them bring closure to their hope that in fact this was fabricated, that their loved ones were somehow hadn't been killed and were being kept in some Bosnian Serb army camp in some prison somewhere in the former Yugoslavia. So this was important in both respects, in respect of the acknowledgement and in respect of the stopping of the denials. And it was Ademovic's confession and of course his assistance to the court that was relevant. I might add that he went on to give evidence against a number of other defendants, including Slobodan Milosevic and others who were found guilty and sentenced. Your Honours, if I might conclude with...
Can I just interrupt you there, Justice Goldstone? I hope that you can hear us, but we seem to have lost connection, so we'll just pause for a moment, if you would, and we'll see what we can achieve. Can you hear me? Nous aimerions essayer d'améliorer la qualité du son. Est-ce que vous arrivez à m'entendre?
The President, the Chamber would like to inform all the parties that due to the technical problem, the Chamber will adjourn for a short time until the IT issue is solved. Probably it's going to take only a couple of minutes. Thank you.
Yes, I'm sorry about that, Justice Goldstone. Can you hear me now?
Yes, I can, thank you.
The connection...
Me when I was dealing with a third.
The connection was interrupted when you were about to say in conclusion, I think, in relation to your first point. You had just finished saying that Adamovich went on to give evidence against others at the ICTY, and you were about to make some other comments. Would you mind resuming from there?
Right. No, I think that at the end of the second point I was making, and the third was very, very shortly that an acknowledgement of guilt, a confession, and assisting the court could well influence other persons coming before the tribunal at a later time to similarly admit their guilt and responsibility. It does create an example that hopefully others will follow. I think those were the main points I wanted to bring to the attention of the court.
Yes, thank you very much, Justice Goldstone. I'm going to hand over now to the President again, and there may be some other questions from members of the trial chamber, and after that there will be questions from the prosecutor, the lawyers for the civil parties, and of course for the defence.
The President, judges of the bench, do you have questions to be put to this expert? The bench do not have questions to be put to this expert. We would like now to give the floor to the co-prosecutors to put questions to this expert, if you so wish. You have 20 minutes for your question time. Co-prosecutor, thank you, Mr. President. The National Co-Prosecutor only has one question for Justice Goldstone. With your leave, I would speak in English for Justice Goldstone. Thank you. Yes, you may proceed, says the President.
Good morning, Justice Goldstone.
Morning.
Right now, I have one question for you related to your testimony today. And first question to you, and how much reliance do international tribunals place on the national crimes national laws of the countries where crimes were committed, like the former Yugoslavia and Rwanda?
Well, Mr. Prosecutor, the status of the ad hoc tribunals, both for the former Yugoslavia and Rwanda, provided that the chambers, that the trial chamber in particular, was obliged to take into account the national laws of the former Yugoslavia states where the crimes were committed, or in the case of Rwanda, in respect of sentencing. It was in respect of sentence in particular that there was this reference to the court of national law.
Thank you, Justice Goldstone. And I give my next floor to my colleagues, international co-prosecutors.
Mr. Justice Goldstone, my name is Anis Ahmed, and I'm the international prosecutor, and I shall, with the leave of the court, submit to you certain observations and elicit your responses to that so as to help this court arrive at a judicious determination of issues relating to sentence of this accused. Just a prefatory remark that I cut my teeth in international law at the Office of the Prosecutor of the ICTY, which you very ably established, and it's my privilege to put these observations to you. As a continuation to my learned national colleague's question, I would request your opinion as to the decision that a court should take when the national practice clearly differs in respect of sentencing of serious crimes. And I'll just give an example. The punishment for a crime of murder in Cambodia would be anywhere between 5 years and life. The conviction rate in this country is very high, and usually we read in newspapers that crimes of murder with malice aforethought get convicted for sentences upwards of 20 years to life. And life in this country, to my awareness, means life in prison unless the King of Cambodia pardons the accused. We heard from you about the lenient sentence of about 7 years granted to the ICTY, by the ICTY to Erdemovich. What would be the reaction of victims, and how would law see the differences of approach in a tribunal established as a hybrid tribunal, which would give a lenient sentence to an accused who may admit guilt of crimes of murder of upwards of 14,000 individuals, helpless victims, and if he were to be given a sentence less than the sentence that an ordinary criminal in Cambodia would get for murder, which may be life. I hope my observation was clear to you, Justice Goldstone.
Yes, indeed, and it clearly goes to the very heart of the difficulty of sentencing for this sort of mass crime, because it's impossible to have any proportion between the number of people killed and the length of imprisonment. Human beings don't live nearly long enough to really pay their debt to the victims and to society. And clearly, courts dealing with massive crimes, with atrocity crimes of this magnitude, have to reserve life sentence as the ultimate sentence, as the most serious sentence, the most difficult sentence, for the worst offenders. So that's where one begins, and one has to scale down in respect of people who are found guilty of lesser offences. Let me immediately say that I wasn't for a minute suggesting that the Erdemovich sentence was relevant at all to the trial which you are prosecuting and which is being heard in your court. I was using Erdemovich only to illustrate the point I was making with regard to stopping fabricated denials and how that is important for society. The reason for the leniency in the case of Erdemovich was the huge duress under which he acted, and that was accepted by the trial court and the appeals chamber. His duress was to the effect that if he didn't participate in the murders, he himself would be forced to line up with the victims and be shot himself. And he was also informed by his battalion commander that they knew where his wife and family lived, and they would suffer also because of any insubordination on his part. So there was duress, which was very important in reducing the period of imprisonment that was meted out to Drazen Ademovic. Having said that, it's not difficult to believe and accept that many victims were reported, and this is hearsay because I had no personal involvement with them, but there was general upset on the part of many victims at what they regarded as an extremely lenient sentence for a person who had admitted murdering their loved one. So this, I think, demonstrates the difficulty which a court has in this situation. And clearly, I would suggest one has to have regard primarily to the victims. International criminal courts and indeed domestic criminal courts are really there to bring justice to victims, and that's an extremely important aspect.
Thank you very much for your observations, Justice Goldstone. My next comment for your opinion would be in respect of two words that you used many times in your initial observations, and they were remorse and guilt, plea of guilt. Clearly, as you observed, guilty plea should be accompanied by remorse for the crimes that occurred. I would seek your observations on the importance of a sincere remorse, a remorse directed at victims, a remorse that tells the victims that I am responsible for crimes that occurred to you or that were committed on you, instead of a general remorse in general for the crimes of the Khmer Rouge or the crimes that may have happened under that regime. How important it is for victims, and indeed for the acceptance of the plea of guilt of the accused, of this sincere remorse. That's the first limb of my submission. The second, Justice Goldstone, would be that the guilt that you plea should be unqualified for the crimes that are charged against you and the way they are charged in the indictment. If there was to be, once again, an admission of a general guilt that I may have been responsible for some crimes in the indictment, and not a specific unqualified guilt of the crimes charged in the indictment, how should the court look at that general qualified guilt? I hope I have been clear, Justice.
Well, I think, it's difficult for me to be, because I cannot obviously on the scale I have give any opinion at all on the nature of the admission or confession made by Duch. I obviously cannot comment on how any confession he's made relates to the actual crimes with which he has been charged. That I would submit with great respect as a matter for the court to determine. But I agree with respect with the general approach of the question you have put to me, that one clearly, if he's to get the benefit of any admission or confession, it must relate to the, obviously, as you said, to the genuineness of that confession, and also the specificity of the confession would be a very important consideration to take into account.
Thank you very much, and I may be running out of my time, but it may be my second last question, Justice. Hope you can bear with me. Just to add to the introduction given by Her Honor Judge Cartwright, this accused is claiming duress and superior orders to claim not complete responsibility for the crimes that occurred, and at least that's the way the prosecution sees it, and the prosecution disagrees on the facts of this case. In the light of this background, I would like to request your comments on guilty pleas that were clearly offered but not accepted by tribunals of the former Yugoslavia and Rwanda. And in particular reference I would make about Jelicic, who was also a camp commander, who also pleaded guilty, yet he was granted 40 years in prison. The case of Kambanda from Rwanda, a very senior figure in the Rwandan government hierarchy, pleaded guilty. The court imposed the highest punishment of life on him. And this is my question in respect of these facts. Can there be a situation in which the aggravating factors be so overwhelming that the mitigation of a guilty plea or some kind of remorse will not make any impact on the sentence at all, just as it happened in Kambanda and in Jelicic?
Well, I certainly, as you point out, that the conclusions of the court in those cases. And it seems to me, though, that one has to deal with each case on its own merits. I think it's very difficult to draw parallels and to draw analogies between situations and situations. I think one has to look at the facts of each case, at the nature of the crimes which have been charged, at the nature of the crimes in respect of which admissions are made, the terms of the admissions, the genuineness of remorse. But it seems to me that a sentencing court has to take all of those factors into account. But again, I come back to the opening remarks I made, and that is that any question of mitigation must be, I would suggest, secondary to the seriousness of the crimes committed and the interest of the victims.
And with Mr. President's leave, this shall be my last question. I hope I have your permission. Justice Goldstone, my reading of the law of the international tribunals, the sister tribunals of this court, is that a larger primary reliance of those tribunals in respect of sentencing has been on deterrence and retribution. And the way those tribunals have justified this reliance is the fact that the crimes are of such magnitude and the nature of these tribunals is so special that there has to be an exemplary impact on the societies in which those crimes were committed, such that those crimes do not get repeated. However, lately there has been some discussion in respect of impact on national reconciliation of these guilty pleas or some kind of expression of remorse. I would request your opinion on what would be the objective criteria to assess the impact of a guilty plea on national reconciliation and justice in the post-conflict society, and in this case, Cambodia. And in particular, what would be the gauge from which this chamber will find the impact on national reconciliation over and above what gets presented in this court? And my submission on that account is that it shall be the acceptance of remorse by the victims and who, unlike other tribunals, are present in this court. What would be, according to you, the criteria other than the observations of the victims and their acceptance of the guilt and remorse of the accused that this court may use for assessing the impact on national reconciliation? I hope that's not a very complicated question. I'm sorry.
Right. Well, I'll do my best to respond to what is, again, a complex question. Reconciliation, national reconciliation, depends not only, as important as it is, but it depends not only of the specific acceptance of the confession and the remorse by the direct victims, but the effect of those expressions on society as a whole. Going back to the South African experience, there were many victims who found it unpalatable, to put it at its lowest, that some of the perpetrators were granted amnesty in return for full confession. And incidentally, in the South African situation, apologies were not called for. So there was no requirement of expressions of remorse, although frequently they were given. But there can be little doubt, in my view, that notwithstanding the unhappiness on the part of many victims, the admissions by perpetrators before the Truth and Reconciliation Commission, the effect this had on our whole society in South Africa certainly greatly assisted national reconciliation. There's still obviously problems. It will take many generations to restore South Africa to a situation where the prejudices and the sorrows and the horrors of racial oppression under apartheid have been put to an end. But the establishment of the truth, the fact that there's a single history of what happened during the apartheid era, which there wouldn't have been but for a quasi-judicial truth commission system, this wouldn't have come about. So I think all of these things have to be taken into account in answering the question as to the effect that a confession and expressions of remorse can have on national reconciliation. It's clearly a complex situation, but it's certainly wider, I would suggest, and understanding as I am of the importance of having regard to the views and feelings of victims, I think the effect on society is a much wider one than that.
I thank you very much, Justice Goldstone, and I thank Mr. President. I have no further questions.
President, next, the Chamber would like to give the floor to the civil party lawyers. You have 20 minutes to put questions to Justice Goldstone. Could you please also tell the court of the arrangement of your questions and the 20 minutes allocated? Would you prefer using the times exclusively for one party representing all or else?
Mr. President, some different lawyers will ask questions. What I can tell you is that it will not take more than 20 minutes as a whole. Can I proceed? Thank you, Your Honor. Good morning, Justice Goldstone.
Good morning.
My name is Alan Werner. I'm representing civil parties in this case. And let me start very, very briefly to give you a little bit of context from the victims, the civil parties' point of view, following the comment from Her Honor Judge Sylvia Cartwright. As Judge Sylvia Cartwright said, it is our submissions that the accused, Duch, does not accept particular facts, and that will be our final submissions. These facts are important ones, and even some are crucial ones for our clients, the civil parties. And last month, in August, about 15 civil parties came to this court and addressed the chamber, and almost all of them were very clear that they were not ready at that point to forgive, but they wanted punishment, they wanted retribution. Now let me simply read two portions of your articles in two different reviews, and let me ask you simply, and you may feel that you said everything already, but let me simply ask you if you have anything to add to that. And the first one will be something you published in 2001 in the Washington University Journal of Law and Policy, page 121. And the title of your article at that time was "The Role of the United Nations in the Prosecution of International War Criminals." And here is what you said about, in particular, about retribution, and I quote, "On the international level, however, the crucial link between criminal prosecution and the preservation of peace and stability shifts the focus away from pure retribution to notions of restoring the rule of law and justly establishing the truth, thereby preventing denials and revisionism. However, clearly punishing the perpetrators of international crimes and providing the victimized population with a sense of retribution does play an important role." Would you have anything to add to that, Justice Goldstone?
No, not at all. I said the view I expressed there.
Very well. The second portion I would like to put to you was an article you were commenting on the writing of another scholar, Professor Drumble, and it can be found in the International Journal of Transitional Justice, page 457, 458. And here is what you said, again, commenting on to the review on the book of Professor Drumble. Here is what you said. "Then there are the problems associated with plea and charge bargaining. During my term as chief prosecutor of both the Yugoslavia and Rwanda tribunals, I was not prepared to consider such procedures. In my view, the atrocities were too heinous to submit to such a course." Would it be possible for you just to elaborate on that point, Justice Goldstone?
Yes, I wouldn't. Here there was a difference in approach between the one I took and which I expressed in what you can to me, and which I still adhere to. Of some of my successes as chief prosecutor of the ICTY. In particular, I'd refer to the plea bargain with Guljana Plavsic, the successor to Radovan Karadzic, as the head of the Bosnian Serb government. She was charged with genocide, and other serious crimes, and a plea bargain was entered into, whereby the prosecutor withdrew the most serious charge and was satisfied with lesser charges. That resulted in what many people regarded as an extremely lenient sentence. The view I took and the view I take is that one shouldn't plea bargain in respect of crimes of this magnitude. I think there's a moral dimension that I found unacceptable to be a party to. And the view I took was that if people accused, if defendants are prepared to plead guilty and to assist the prosecution in respect of investigations, whether in respect of the trial of the person or on a wider basis, those are matters which the prosecutor should bring to the attention of the trial chamber and make an appropriate submission that if it's genuine it should be taken into account in mitigation of sentence. So that's a very far cry from plea bargain. And I'm suggesting, I think in the evidence I gave earlier this morning, I was suggesting that it be taken into account in that respect, and certainly not. I was not suggesting at all that it should lead to a finding of guilt on any lesser basis.
Thank you very much, Justice Goldstone. I have no further questions.
The President, civil party lawyer of other group, you may proceed. Mr. Kong Pisai. Good morning, Mr. President, Your Honors, and good morning, Justice Goldstone. My name is Kong Pisai, the National Council for Civil Party Group 2 and 4. I would like to put two questions only to you. First question, it is about the remorse and the confession. To me, only when he is received, when there is a more than 95% of the proofs that he is guilty, that he is in the position to express his remorse and accept such, acknowledge such guilt. So and the word apology, normally apology has to come all the way from his heart, but according to our law, and as the arguments that you have already stated earlier, that the person who committed a crime, who killed someone and then was sentenced to only 7 years. And I don't know how genuine an apology is for the victims who have survived the regime feel satisfied with such apologies. My second question is in relation to the civil parties' reparation. Should there be civil party reparation for the victims? If so, what or how could civil party reparation be granted and in what form?
Well, thank you. As far as apology is concerned, I certainly would suggest that that's the lower end of the relevance of the issues we're talking about. It's very easy for people who admit guilt, who confess to guilt to apologize. It's difficult, it's very difficult to judge the genuineness of making an apology. What I would suggest is more important are the terms of the confession and the admission of guilt. That is really what I would suggest is important to the victims. An admission of what happened to their loved ones or to them, if they are the victims themselves. It's very important for them to have that acknowledgement and that confession from the person who was the author of their victimization and terrible misfortune. So I wouldn't put apology anywhere near the top of the factors to take into account in certainly in mitigation of sentence. Reparations clearly are important, not only for the victims, but I think for reconciliation. It's always a difficult issue because reparations require funding, require money, and often there's no source for the payment of those reparations. It's been a problem in South Africa where the post-apartheid government, the democratic government of South Africa, initially under the presidency of Nelson Mandela, had a problem because the victimization of the majority of black South Africans by the apartheid system, in fact of all black South Africans by the apartheid system, couldn't be laid at their door. They were victims themselves of that, and the issue was whether their government should have to pay reparations for the crimes that were committed and the indignities that were visited upon South Africans by the apartheid government. And it caused a lot of political agony when, in the end, reparations were paid to victims identified by the Truth and Reconciliation Commission, but at a level that the victims found significantly inadequate. So it's always a difficulty. I think it's very important, though, that there should be reparations, whether it's to assist the survivors with education or even memorializing the events that happened. I think these are very, very important aspects, and it obviously will depend on the situation in the country concerned. As I say, particularly the financial resources that are available. But to the extent that reparations are possible, I have no doubt that they are extremely important and can be very helpful in repairing society.
The President, Civil Party Lawyers Group 3, you may now proceed.
Good morning, Justice Goldstone. Well, to quickly summarize, you have experience of ad hoc tribunals, and we agree that confession and admission of guilt is very important for the victims and parties. Can you tell us if this has had an impact on reconciliation? As we saw on a CD which was distributed to us, Serbs and Bosnian Muslims, is it possible for them to have a cup of coffee together, or is it the case that the events that have taken place in Arusha have had an impact on national reconciliation?
Does the question relate to Rwanda? I missed that.
No, the question has to do with the impact in countries where tribunals, such as ad hoc tribunals, were established for the former Yugoslavia on the one hand and Rwanda as well. because the court was in Arusha, but it had an impact on Rwanda. So decisions that were taken where there were guilty pleas, did that make it possible to advance the cause of national reconciliation?
Yes, I believe it did, and again, I don't want to repeat what I said earlier. But the most important area was in putting an end to fabricated denial. You know, when the Yugoslavia Tribunal began, all three major groups, whether the Croats, the Bosniaks and the Serbs, all believed and all certainly proclaimed that they were victims and the others were perpetrators. I have little doubt that the work of the Yugoslavia Tribunal has helped bring about a situation where all people in the former Yugoslavia have had to accept that all of them were to a greater or lesser extent both perpetrators and victims. And it's that acknowledgement and the putting to an end of denial, I believe, it can play a very important role in bringing about reconciliation. Having said that, of course, the former Yugoslavia still has quite a road to travel before true reconciliation and enduring peace takes place. In the case of Rwanda too, when the Rwanda Tribunal was set up, there were many people, both in Rwanda and certainly in some European countries, who denied that there had been a genocide at all. Many people put it down to allege that this was some sort of spontaneous combustion. It was what one, and they would. Many people were demeaning about it. This is what happens in Africa. As an African, certainly I found that quite insulting, if not abhorrent. But that was a view that was put forward. I think that the work of the Rwanda Tribunal has also put an end to those sorts of attitudes and those sorts of denials. And there's today an acceptance by all parties in Rwanda and outside Rwanda that what happened in 1994 was a very carefully planned and unfortunately brilliantly executed genocide that caused the deaths in less than 100 days of some 800,000 people. So I think the work of the tribunals in both cases have had a very positive effect. I think too, in the case of Rwanda, they have made possible the use of the what's known as the Gacaca system, using customary procedures in Rwanda to bring speedier justice to many tens of thousands of people who are being kept in prison. So I think the work of the tribunals have assisted in the ways to which I've referred.
The President, next, we would like to give the floor to the Defense Counsel to be able to put questions to Justice Goldstone.
Merci, Monsieur le Président. Bonjour, Monsieur le juge Goldstone.
Thank you, Mr. President. Good morning, Justice Goldstone. Thank you for being with us this morning to take part in this important discussion. I understand that the questions that are put to you can sometimes be of a sensitive nature because all sides will be trying to bring you closer to the actual ground of the case we are dealing with here, in spite of the fact, of course, that you don't have all the elements at hand to form an opinion. However, in order to bring clarity to the discussion and to set out the more general questions I would like to put to you, I would like it to be very clear for you that it is indeed the case, as Judge Cartwright has recalled, that Duch did acknowledge his responsibility for the entirety of facts that are held against him, even if, and I'm sure you've understood, the prosecutor's office and civil parties still consider that he has not said enough. But in order for things to be very clear for you, again, I wish to confirm that the investigating judges who heard Duch for over a year, in the presence of prosecutors, these investigating judges who organized a reenactment on the location where the crimes were perpetrated, in the presence of the accused, of the prosecutors, and of some of the survivors, these investigating judges concluded their investigations with what is called a closing order in civil law, which states as follows in paragraph 167. Duch always acknowledged his responsibility as head of S21 for the crimes that were perpetrated there. He explained that he had broken his silence in 1999. For your information, prior to his arrest, due to the fact that he felt that one could not refrain from saying the truth about S21, after having heard statements made by Pol Pot, who denied the existence of S21 and claimed that this was a Vietnamese fabrication. And the judges added, Duch, on a regular basis, has expressed remorse both to the victims and to their families, but also to the former employees of S21 who were under his command. In the following paragraph, the judges state, furthermore, Duch has voluntarily cooperated during the investigation and refused to implicate any of his subordinates, and placed the full responsibility on the top levels of the party in order to exonerate himself. I would further add that appearing before this chamber during proceedings, as Judge Cartwright stated, do continue to cooperate. Duch
85%
recognized 85% of the facts put before him by the prosecutors. And lastly, the psychology and psychiatry experts said the other day at the bar that Duch was a person who had come out of denial and that he was now in a process of self-accusation. This is simply to give you adequate information, Justice Goldstone, so that you may understand that the reason why the defense has sought your testimony is clearly because it feels that we find ourselves here in the presence of someone who is genuinely pleading guilty, who is seeking forgiveness from the victims, even if the co-prosecutor's office here in Phnom Penh doesn't really understand this guilty plea, and even if they did understand it, the victims have not heard either the request for forgiveness. Now this will call me to ask a few simple questions, very simple questions, with regard to the jurisprudence of tribunals where you were prosecutor. And you recalled, and I thank you, the Erdemovich case. You recalled that Erdemovich did plead guilty in the Srebrenica case and that he was being accused of the death of 70 persons. I wish also to recall the Obrenovich case. Obrenovich, who had been accused of killing 6,000 people in 1 week, and who pleaded guilty from the outset, and where the chamber indicated the following in its judgment, paragraph 115, for instance: the trial chamber observes that by acknowledging his responsibility and guilt, Dragan Abranovich has never sought to find excuses for himself, nor did he attempt to convey the responsibility for his acts on other persons. Given these considerations, the trial chamber concludes that the guilty plea of Dragan Abranovich represents an important mitigating circumstance because it contributes to the establishment of the truth, it favors reconciliation, and because Dragan Abranovich has accepted without reservation to take on his individual criminal responsibility for the role that he played in the persecutions.
au banc de la défense, Monsieur le juge Goldstone, nous considérons pour notre part
Well, Justice Goldstone, from the side of the defense here, we consider that Dragan Obranovic and Duch are in the same situation. It seems to me, and that is one of my first questions, it seems to me, Justice Goldstone, that the jurisprudence of international criminal courts has looked into the issue of the genuine nature of remorse that was expressed, and that on several occasions it has indicated that the best way to determine whether remorse is genuine was in fact the degree of cooperation that was given to the Office of the Prosecutors and Justice in general. Are you in a position to confirm that the degree of cooperation is one of the means available to verify the sincerity of the remorse that has been expressed?
Well, indeed, I agree with your preamble to the question. I agree too with the question. Obviously, the question of fact, the degree of cooperation and the extent of the confession are matters of fact to be determined, I would respectfully suggest, by the trial judge.
J'ai personnellement mené au tribunal d'Arusha
I have personally
plusieurs plea agreements.
submitted several plea agreements at the Arusha Tribunal, two in fact. One which led to a film being made, perhaps you've seen it, a film prepared by the services of the Arusha Tribunal, which is called in French On the Path of Reconciliation. And that is the degree to which the government of Rwanda, in fact, acquiesced to the fact that the guilty pleas in Arusha were, in fact, helping reconciliation in Rwanda. When I negotiated guilty pleas with your colleagues from the offices of the co-prosecutors, we agreed that the prosecutor would abandon certain of the charges, certain facts for which proof was not necessarily obvious, but that this would be done to the benefit of what he and what we considered to be essential. In other words, the acknowledgement of responsibility concerning the major charges. And in the two guilty pleas, the two guilty plea agreements, we agreed with the prosecutor so that the latter would abandon certain charges and let go of certain facts in order to focus on what was essential, which was the acknowledgement of guilt. Can you confirm to this chamber that this is a practice that is in no way scandalous insofar as it will make it possible for the accused to admit to facts which he sincerely expresses guilt for, and enables the prosecutor to leave by the wayside facts of a more secondary nature which are challenged perhaps by the accused and about which the prosecution perhaps does not have sufficient elements to achieve conviction.
I have difficulty in understanding the link between between plea bargaining on the one hand and cooperation and a confession and remorse on the other. I'm not suggesting they're inconsistent. I accept completely that bargain can result in cooperation and admission of guilt. In other cases, it may have effect where the effect of the plea bargain is to really to put under the table and to put out of sight some of the more serious offences, and that of course can have a very negative effect on victims. But in all of these cases, it's a matter for the trial judges to determine questions of fact, namely the extent and genuineness of the confession and the genuineness of expressions of remorse.
Oui, merci, Monsieur le juge, de rappeler qu'effectivement,
Thank you, Justice, for recalling
agréments
that in fact plea agreements are always put to the chamber and the chamber always has to decide whether a plea agreement is consistent with the aims of justice. Since this morning, a number of questions have been put to you and you have responded with reference to the victims.
De l'expérience que vous avez comme juge, comme procureur,
from your experience as a judge and prosecutor,
dire que les victimes,
can it be said
d'une manière générale,
that in general,
sont toujours satisfaites
victims
et apaisées
are always satisfied and mollified by the decisions that are rendered?
tellement énorme
Is their suffering
que de toute façon,
not so great
elles ne pourront pas
that in any event
accepter une sentence quelle qu'elle soit?
they will not be able to accept a sentence, whatever it is? Is this not, generally speaking, the situation we are faced with now?
I have difficulty. What is the
difficulté à bien comprendre.
Je vais essayer de reformuler ma
I shall
question.
try to put my question again.
La pratique que vous avez des tribunaux, et je pense pouvoir dire que j'ai
Based on your
également
experience of
aussi une
tribunals,
assez longue pratique,
experience which I may lay some claim to sharing, is it true to say that, generally speaking, in light of the suffering that the victims have endured, they are never really satisfied with determinations of courts because they find that such decisions are always insufficient? Do you share this view?
I think it's an overgeneralization in respect. I don't believe one can generalize. I think some victims react in the way you've suggested. Other victims don't. I think there are almost as many reactions as there are victims, and it's certainly been my my experience in South Africa and also in Rwanda and the former Yugoslavia, that while many victims are dissatisfied with the justice that they've seen or heard in these tribunals, others have had a more positive reaction and have been enabled to begin their healing process. So I think one shouldn't generalize.
Vous l'aurez compris, ma question
As you will have understood, my question is much more geared towards what we're experiencing here in this court. Whatever the regret, the remorse, the apologies that the accused may proffer, the victims cannot hear him. They cannot hear him. Because their suffering is too great.
It's a question of fact. I just don't have sufficient to make any serious contribution to that discussion.
Je pense qu'effectivement, je ne suis pas en mesure de contribuer au débat dans ce domaine et à ce propos.
Oui, je vous en remercie, Monsieur le juge. Une dernière
Mr. Hall,
question.
thank you, Justice Goldston.
Vous avez
One last question.
tout à l'heure et je vous suis tout à fait.
You made the point earlier, and I follow you, when you said that the importance of an admission of guilt is that it puts an end to denial. Do you think
reconnaisse sa responsabilité pour la première fois
that a person who admits his guilt for the first time in respect of the Khmer Rouge regime,
pour la première fois, le fait qu'un Khmer Rouge reconnaisse publiquement sa
do you think that when a Khmer Rouge acknowledges responsibility for the first time,
d'une part, a suscité
this
la même démarche chez
might
d'autres accusés,
arouse the same impulse in other accused persons and also
dans la société.
bring more peace to a society?
Absolutely. If in fact the court finds that the confession and the remorse are as you put it to me, as I indicated in my opening remarks, this would be a very important factor that would have positive features. Some of them you've mentioned, others you haven't. I think it's an important example that hopefully will induce other people to come forward. The fact that if as you say, it is the first admission to come in the decade since the Pol Pot regime, that would be important. I don't believe justice can ever come too late for victims that survive. And I would respectfully suggest that would be an important factor to take into account with regard to mitigating sentence.
Un facteur important à prendre en compte dans le cadre de circonstances atténuantes.
Monsieur le Président, je n'ai plus de questions.
Mr. President,
Merci encore
I have no
d'avoir
further questions.
accepté de
Judge Goldston,
participer à cette
thank you
audience à
for
distance.
agreeing to
Malgré le décalage
participate
horaire. Merci beaucoup.
in this hearing in spite of your remote location and the time difference. Thank you very much.
The President, the Chamber would like to thank the expert, Justice Goldstone, for your valuable time to respond to the invitation by the trial chamber for your testimony as an expert, as well as the content of your testimony. And the chamber will take your testimony into consideration when we make our judgment fairly on this case. And your contribution is valuable to the proceedings before this chamber in finding justice for Cambodia and for its people. The hearing of your testimony is now come to an end. Thank you. The President, the chamber will take 20 minutes break and we will resume at 11:10. Parties to the proceedings and the public are reminded that when the chamber resumes, it will hear a testimony of the expert Raoul Majena. The expert was scheduled for the afternoon, but due to the quicker time for the hearing of the testimony of Justice Richard Goldstone, so we will hear the testimony of the next expert after the chamber resumes this morning. And we will continue in the afternoon if it does not finish this morning. The hearing is now adjourned. All rise, says the greffier.
Ce matin, la greffière, veuillez vous lever.
The President, please be seated. The court is now back in session. Civil party, the defense counsel, you may now proceed.
Au Conseil de la Défense qui souhaite intervenir, je vous en prie.
Merci, Monsieur le Président.
Thank you, Mr. President. I wanted to react to the question which was put to the expert by my colleague from the civil party, which is awkwardly put to the expert. He's not supposed to be replying. It is for the defense to reply. And the defense, within the scope of its powers, has requested the possibility of having in its team a consultant. Perhaps it has escaped the scrutiny of the civil parties that all of this was done according to the rules and that everything is in the case file. The authorization to communicate prepared by the investigating judges authorizing Mr. Génard to visit the accused as is necessary, which is what he did. I have not requested from you the notes taken by your expert, Dr. Souterra, during his consultations with your clients, the victims. So please be kind enough not to demand from Mr. Raoul Genard that he supply the notes of his communications with the accused. You were entitled to experts. The defense is entitled to experts. Mr. Genard prepared a report. The report has been filed. It is perfectly transparent, and you may freely question him both on the content of the file and on the oral presentation that he made earlier before this court. Thank you, Mr. President.
The President, civil party lawyer, you may proceed. Mr. Kaing Guek Eav. Thank you, Mr. President, Your Honors, and distinguished members of the court. Good afternoon, Mr. Genard. My name is Kaing Guek Eav. I would like to put two questions to you, and I would like to leave the rest of the time allocated to the rest of the members of the civil party lawyers. I'm here on behalf of Group 2 and Group 4. I may go back a little bit to the matter of the arrest. As we are aware already, in Lone North regime, in 1973-4-5, say the civil party lawyer, Phnom Penh was not yet fallen, and the Khmer Rouge sent their network to Phnom Penh. Some of their men were placed in some pagodas and other places. And when the Khmer Rouge took control of the regime, then they took power, and Phnom Penh was under their power. And since they used to deploy their spies to different places, so during the time when they were in power, they were suspicious of people who they perceived as suspicious, and especially people of the 17th of April who were accused of being enemies and later on were executed. Most importantly, when people were interrogated, the confessions tend to be opposing the Khmer Rouge, or correction, to opposing themselves, the person who gave confession. So none of the confession is not against themselves or self-incriminating. And my question is, have you discussed with the accused the reasons why such confessions were taken, and that only the incriminating confessions were taken?
Merci.
Thank you.
Maître, bien entendu, je l'ai déjà dit tout à l'heure, la question des
Of course, I've already said that earlier. The question of confessions is a central issue, both to understand S-21 and the entire terror-based system of democratic Kampuchea. This
méthodologie un peu particulière, on en conviendra,
somewhat peculiar methodology, I'm sure you'll agree, designed to extract from persons who are arrested a statement
ce que le pouvoir, ce que le comité permanent
reproducing what the power, the standing committee, the Kampuchea leadership wants them to say was clearly the objective that was sought. One should never forget, and it was the same in the Soviet Union, that to be arrested meant to be sentenced to death. So there was no attempt to modulate a penalty in any way whatsoever. The only purpose was to compel the person in detention to say what the power in place wanted the person to say in order to be able to continue to pursue a policy of repression. One should not forget that the machinery of confessions is part and parcel, as I said in my introduction, of an attempt to search for the internal enemy. Now, this can be assimilated to paranoia. I don't have the knowledge, scientific knowledge to do this, but once the power structure has understood this, and it also came from the training they received at the level of international communism, once you are aware of the existence of an internal enemy, the people you are arrested must be compelled to say who is the internal enemy, that they are part of it, and that others whom they know are also part of the internal enemy. That is not simply designed to find the person being interrogated guilty, but also to get more names in order to arrest more people.
Council, thank you, Mr. Chenard. The next question, I may proceed. It is related to the public administration being implemented at S21. Have you also discussed this matter with the accused in relation to how public administration was being handled at the vicinity? I would like to give a clue in relation to this matter. It is about the political arrangements or administrations, or how works were done.
Non, maître, je n'ai pas abordé cette question avec
no, sir, I didn't broach this question with the accused. My main concern was to identify the ideological origins, the sources of inspiration, the manner in which the accused and the system of which he was a servant had finally come to do what they did, and where they drew inspiration for that. Thus, I did not dedicate my interviews with him discussing the internal modus operandi of S21. And in fact, this is work that was being carried out by the investigating judges, so it wasn't really my task to do it. We got a great deal of information concerning the structure and organization of the center from them, as well as the internal organization of the center.
Civil Party Council. Thank you, Mr. Chenard, and thank you, Mr. President. I have no further questions, but I would wish my colleague to share the allocated time to put questions to the expert. The President, the Civil Party Lawyer Group 1, you may now proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Good afternoon, Mr. Genet. My name is Alain Werner, and I represent civil parties on behalf of my colleague Shrina. And I have a few questions for you. We have very little time, thus I would be very grateful if you could give succinct answers, and that would probably make it easier for me to ask more questions. Now, I'd like to follow on one of the questions that you replied to coming from the co-prosecutor, and we certainly have questions about sources. You said that intermediate cadres were purged inside the country, and so what are the precise sources that you rely on to say that, and if you do have some, could you give us the names of some of these intermediate cadres? Well, I confirm what I said to the co-prosecutor. The sources I relied on or the sources available in DC CAM. So I wouldn't be able to give you names here and now. But to my knowledge, the archives of DC CAM are accessible, certainly by to the civil parties. A question. You stated in page 7 of your report in French, VRN 00187717, you said about DC CAM, an organization, operational manual practically identical for all the centers regarding methods to be employed, including description of the tortures, and it is a description of practices which were begun in various security centers during the war in 70 to 75. If I understand this correctly, the interrogation manual which you mention is in fact a manual that was written by an S-21 interrogator. What are your sources? What enables you to contend that a manual that was practically identical was used in all the security centers? What do you rely on in order to make this assertion?
Lors de mes entretiens avec l'accusé,
answer. Well, from my interviews with the accused, I asked questions on the issue of training. I was concerned with knowing where these techniques came from, who had taught them, who had learned them, and I already had the opportunity to mention Sun Sen, but also, as I mentioned in my introductory statement, the torture, what was later called the torture manual, which is in fact an operational manual, which was drafted in S-21. There were training sessions organized by Santebal for staff other than the staff of S-21, and one could find there persons in charge of other security centers. And question. And so this last assertion is based on what the accused has told you. Is that correct? Could you repeat? We didn't hear your answer. The microphone was not on. Microphone is still not on. Yes, I confirm that it was based on interviews with the accused. Dr. Hutchinson at this bar did research, mentioned sources, said that torture methods in S-21 were distinct from those practiced in other detention centers by their cruelty and number. And as a matter of fact, you did refer to that earlier. But let us be specific. What specifically in your research enables you to express a divergence with the doctor and to give us an opposite opinion from what he gave? We don't have any contrary indications that would enable us to state imperatively that methods of investigation in torture used in other security centers were of a softer or kinder nature than what was practiced in S-21. And insofar as And I said that in my previous reply. Insofar as there were training sessions for the members of the security services of different centers, there's no reason to believe why in certain cases some would not use some of the methods that were being applied in S21. Question. You discussed confessions. Now, to get a clear understanding of what you're saying, is it correct to say that when we speak of confessions in the detention centers inside the country, we can't give any details because most of that material was destroyed? Is that what you said earlier? Reply. What I said and what I repeat now is that a scientific approach imposes caution. It isn't because we didn't find anything that there weren't any. It was easier, there was more time to destroy them than in S21, where the director was told by someone who was in a high position, senior position in the KDP, that there was no risk that Vietnamese would come in. A question. Contrary to what you seem to be asserting, if I understand you well, the accused accepted during these interviews that lists of enemies were prepared at the end of confessions by the detainees of S21 at the request of the accused and of staff of S21, and therefore lists of accused and enemies prepared by those who confessed at S21 were circulated throughout the country. And when I handed him one of these documents, he stated that, in fact, staff of S21 compiled, analyzed these lists, and certain persons, not the accused, but certain persons, in fact, came and confirmed the fact that these lists were disseminated. My question is the following. Are there elements in your research that are precise and source-based that would allow you to say that such lists of enemies, that such a system of lists of enemies and hunt for enemies was organized throughout the other centers, in security centers in the country as well? Answer.
Monsieur le Président, merci, Monsieur le Président. Je souhaiterais que Maître Werner
Thank you, Mr. President.
nous donne la référence du moment où
I would like Mr. Werner give us a reference of the time when the accused recognized the existence of thousands of lists. I hear what Mr. Etchison. I never heard that the accused had recognized or acknowledged that there were thousands of lists. So please, if you want to ask this type of question from the expert, also quote your sources. Let me reformulate, says the Civil Party Council. The accused admitted that there existed lists of enemies prepared in S21 by the prisoners themselves. He also admitted the fact that the guards at S21 prepared summaries and analyses of those lists. And Dr. Hutchison, with regard to these two categories of lists, said here that there are probably thousands of lists in each one of these categories. And my question to you is whether there are specific elements in your research that enable you to state that such lists of enemies existed anywhere other than S21.
Je voudrais tout d'abord que j'ai un peu un problème avec
First of all, I must say that I have a problem with the expression list of enemies. With regard to the confessions that I was working on, there are names, but I'm not talking about lists. There are various names that emerge. So what I know, the lists that I know about are lists that were prepared after the fact. The prosecutor spoke of a list of over 40 persons coming from different security centers. These are lists that were prepared later on the basis of people who came to S21 and underwent the fate that we know. I am personally not aware of the existence of lists that would have been prepared, of lists of enemies that would have been prepared prior to their arrest. Perhaps I misspoke, says Civil Party Council. I was speaking of lists that would have been prepared at the end of confessions, lists containing names. Answer. The expert, well, the term list remains equivocal. In fact, list, there were names at the bottom of confessions, but speaking of list might lead one to think there were thousands of names, and I'm not ready to say that. Question. Mr. Genat, you mentioned, and in fact it is the topic of your report, of the climate of terror, secrecy, permanent purges. How do you explain that the accused managed to remain for 9 years, from 71 to 79, managed to remain successively at the head of 2 detention centers without being purged himself? Reply. To answer your question would presuppose that purges follow a logic or a rationale. I could answer by asking the following question. How do you explain that a certain number of leaders, members of the Standing Committee and the Central Committee, were not purged, whereas others were? This falls in the category of the irrational, of obsession with the enemy, or because political explanations are not always genuine motivations. There may be in the leadership of a party, as in the leadership of any country, a situation of rivalry, so that could be a cause. And I would like to add, because this was an important factor, this sort of obsession about seeing in anyone who seemed uncertain a traitor, KGB, CIA, or Vietnamese agent. And once this doubt was born, to go back to Lenin's words, then that person became an enemy. Why this one in particular did not become one? Many say that a certain number of leaders of democratic Kampuchea, had the regime lasted a few more months, would not be available before your chambers today. There is an irrational quality to a system where everyone is suspicious of everyone and where the sole response is a purge. Last question, and I'm done. There is an interrogator whose name is Prapkan who spoke here, and that interrogator stated under oath, and the French reference 003566128, on 22 July 2009, stated that approximately no less than 300 persons of Division 703, persons who were working in S21, were purged between 75 and 79. And when he was questioned about the reasons why almost the entire 703 division was purged in S21, and the interrogator confirmed what he said to the investigating judge, was that according to him, the reason why so many people from that division had been purged was that the accused did not want the 703rd Division to acquire too much power, and that the accused was afraid that he might not be able to remain the director of S21 forever. So my question is, my last one, is it not the case, now that the dilemma is no longer to kill, to avoid being killed, but that he would have killed even his own staff in order to stay in power? Do you have any comment you wish to make with regard to what Mr. Pratkan said? Well, I feel like telling you that we're fully in speculation mode here. What are the deep motivations, if one has no objective material element to rely on, depending on whether you wish to charge someone or remain with the information, you can say, well, yes, why not? There was a question of power more than anything else, or you'll say the exact opposite, depending on what your position is. So I would stay away from any form of speculation. Yes, Civil Defense Council, I have no more questions. Thank you for answering my questions.
The President, the Civil Party Council, Group 3, you may proceed.
Monsieur le Président, c'était pour vous dire que
Mr. President, I was just going to say that we are satisfied with Mr. Werner's questions and we do not have anything further for the witness.
The President, the Chamber would like now to give the floor to the Defense Council so that you can put question to this expert if you so wish. Thank you, Mr. President. Good afternoon, Your Honor. Good afternoon, Dr. Jenner. I would like to read through portion of your report. As you stated, amongst the 196 detention centers, the head of those detention centers shall be categorized as responsible for the crimes committed during such time. I would like to seek your further enlightenment on the report. You described about the detention center from Chongchrui until the S21, and that they should be felt within that category. However, in all the DC camp reports, as well as in yours, the 196 security centers, amongst those, only 64 have the figures of the victims or the dead. Therefore, the chairpersons of the 10 security centers are among those 64 security centers which have some surviving documents. Are these what you meant in your report?
Merci, Maître.
Thank you, Counsel. What it seemed important to me, for me to do, was that there was a generalized system which covered the entire country, and on the basis of the information collected, and I repeat here that we must be careful. The statistics of horror are only statistics, and statistics are fragile if you have nothing other than the skeletons from the mass graves around detention centers. Having recalled that, it seemed important to me to nuance what I refer to as the subjective specificities of S21, to emphasize that there was a large number of victims, tens of thousands of victims, more than those that were found in S21. So there were nine centers where there were more victims than in S21. And for those centers, nobody is before this court.
Si je peux me permettre,
If I may, be so bold with all due respect to the court. My concept of justice is not to have scapegoats. It's to treat everyone the same way. It is known, but please don't ask me to name names. Do not ask me to do what those who should do it do not do. But it is known that there are 9 centers where there were more dead people, more victims, more tortured people, more people massacred than S21. There are a number of the directors of these centers who are still alive. I wanted to emphasize that.
Kasabut. Thank you, Doctor, for your response. My question is that among the 196 identified security centers in the DC camp and in your report, only 64 have the statistics of the dead, and the rest did not have any surviving documents or statistics. My question is, the 10 security centers that you quoted in your report, were they 10 amongst those 64 security centers?
Ma réponse est oui.
My answer is yes. In my expert report, if I decided to remain silent on the others, it is, in fact, because there is a requirement of painstaking research, and if I found the information not to be reliable, I preferred not to use it. I did see this. You could go to S21 on the first floor of Building B. There are statistics for a very large number of security centers. In some cases, my personal view is that the figures will not stand up to scrutiny. I don't want to say they are fictional because I have too much respect for the victims. I did not wish to go out on a limb apart from on those 64 centers I have mentioned.
The President, thank you, Doctor. Also, in your report, you stated that the 10 chairmen of the security centers out of those 64 security centers fall under the category of those most responsible for the crimes and serious violations of Cambodian and international law. My question is, in your report, the letter dated the 30th of March 1976, which the Standing Committee of the CPK designated authorities to the 4 groups who have the authority to decide on smashing inside and outside the party rank. So the combination of these 2 portions of your report, particularly the 4 groups with the authority, namely within a zone, the security of the zone has the authority to smash. And at the offices around the central office, the office 870 is having that authority to kill anyone. And in the independent zone, the Central Committee itself has the authority, and within the army, Son Sen, the General Staff, has the authority to smash. So my question is, amongst the 4 groups, are they those people who fit the category of those most responsible for the crimes? because the party already designated them the authority to smash people, so they should be the most responsible. And in your opinion, will they fit into such a category? Thank you.
Counsel, I'd like to put a question to you. Is there a gradation of the seriousness of crimes, regardless of cause, whether that is depending on whether you are a prison head in Phnom Penh, Kampong Cham, or Kratie? My answer would be yes. These heads of security centers, it's not because that they are in the provinces, as one might say, that their responsibility is diminished. So they should be charged similarly.
Thank you, Doctor. Your response seems not direct to my question. What I really want to know is that in your report, you clearly stated that the 10 chairmen of the security center fit the category of those most responsible for the crimes, etc., during that regime. And my question is, the 4 groups that were designated authority by the party to smash anyone, will they also fit into the category of those most responsible for the crimes and serious violations? Thank you.
If I understand your question correctly, Counsel, and if I call to mind also the law establishing the extraordinary chambers in the courts of Cambodia and the Security Council resolution and the agreement between the United Nations Organization and the government of Cambodia, there are 2 categories of persons: the major leaders and persons responsible for grave breaches of Geneva Conventions and crimes against humanity. In my view, the persons you're referring to in each of the 4 categories fall within the ambit of the second group of persons, which is referred to in the law and the Security Council resolution. I hope I have answered your question now.
Kasabut, thank you for your response. And in your last response, you mentioned that the 4 groups of people also fall within the second category, that is, those most responsible for the crimes. Thank you for that. And I have a small question for you in addition to that. In late 2007 or early 2008, I met you, Doctor, and we discussed some issues, including the reports and documents of the DC camp and your report, and that one detention center in Ba Phnom Prey Veng was not researched. In Prey Veng, you only talk about the Kam Chai Mea district, Kampong Tro Bai, Kanh Kriek, Me Sang, Piem Cho, Prea Sdach, Prey Veng, and Sitho Kandal, except Ba Phnom Detention Center and the Ba Phnom district. I used to be imprisoned there, in the Churul prison east of Ba Phnom, and that was the largest prison in that zone. It was located on the top of the mountain, and several senior leaders of the cadres were detained there, and later on they were executed at S21. The question is, did you have you done any further research in your study to include the Ba Phnom district into your database?
Non, maître. Je n'ai pas fait de recherche complémentaire.
No, Counsel, I have not conducted further research.
Kasabut, thank you, Doctor. With the President's leave, I would like my International Defense Council to take the floor. Thank you. The President, International Defense Council, you take the floor now.
Merci, Monsieur le Président. Bon après-midi, Monsieur le Président.
Thank you, Mr. President. Good afternoon, Mr. Jinnah. We have a few more questions for you. Thank you for your contribution. Mr. President, first, I would like to draw to the attention of my colleagues in the Office of the Co-Prosecutor that the defense, as you may not know, has prepared a list of documents at D80. This includes 3 documents at D88, D89, and D8010, which are DCCAM documents. Mr. Jinnah, the defense filed these documents. Forgive my translation or my pronunciation. This is about 3 documents from DCCAM, and I would like to know whether you had the opportunity to go through these documents. With reference to the first document, D80/8,
in Cambodia, et en français 1975.
And in French, it is 1975 to 1979.
Programme, Yale University, editors Susan Cook and Matthew Fladland, June 2001. C'est le premier document.
That is the first document. The second document, D80/9,
Composite Landsat Satellite Image of Cambodia, 72-76,
72 to 77, and 1990,
and prison sites from
with mass graves and prison sites from 1975 to 1979. This is part of the Cambodian genocide program of Yale University as well. You can view the documents on the Yale website. The third document is Mapping the Killing Fields in Cambodia, 1975 to 1979, DCCAM, 2001, in English and in Khmer. Sir, to the best of your recollection, are these documents amongst those that can be viewed and that you yourself saw in DCCAM's offices?
Merci, maître.
Thank you, Counsel.
J'ai une réponse très brève, évidemment.
I have a very short answer. Obviously, you have given the complete references of this document, and you are not unaware that before they were placed in DCCAM, they were noted in the Cambodia genocide program where I worked. So I'm very familiar. I'm highly familiar with these documents. I would like to indicate to the Chamber that by a letter of the 9th of May 2008, that is D80, we filed these documents with the co-investigating judges. Of course, my colleagues in the Office of the Co-Prosecutor and the civil parties necessarily have knowledge of these documents. I would like these documents to be put into evidence. They are in the case file, but I would like them put before the court as evidence.
Monsieur l'expert, avant vous à cette barre sont venus
Mr. Jenner, several witnesses have preceded you, including somebody you know very well. He's a researcher like you. He's Mr. Kaing Guek. I think you may have seen the written report of Mr. Etchison in the case file, and perhaps you may not have been aware that Mr. Etchison departed quite significantly from his written report when he gave testimony, and I may even say that he contradicted himself. Amongst the things that he contradicted, he particularly challenged the accused's statement when the accused said that he had daily interviews with Son Sen, or daily conversations with Son Sen, and that Son Sen demanded that this should be so. The accused explained to the court that Son Sen monitored on a daily basis the activities of S21 and required a daily report on what occurred at S21. In most cases, the report was delivered by telephone. Mr. Etchison said Mr. Son Sen was very busy, and I have doubts as to whether he would have been able to concentrate on S21 on a daily basis. This morning, with regard to the chain of command, you said to the chamber that who Mr. Son Sen was. On this point, can the accused's statement be subject to challenge, as Mr. Etchison believes? Or, since you know the chain of command in democratic Kampuchea, you think, on the contrary, that the accused's statement on this count is credible? Counsel.
Monsieur Son Sen était sans doute très occupé.
Mr. Son Sen was obviously very busy. He was very busy going about his duties. One of those, and not the least of them, was to be the first-level person in charge of the security policy and answerable to his colleagues in the standing committee. Mr. Etchison and I were not in a position to record the telephone conversations, if they did occur, between Mr. Son Sen and the accused. But in light of Mr. Son Sen's responsibility to the heart of power in democratic Kampuchea, it is plausible to consider that he might have been concerned enough to monitor the security center, which depended directly on the standing committee. So I am inclined to consider that in this respect, the information provided by the accused have a high degree of credibility. Question. You talk about this monitoring by Son Sen, who had to report to the standing committee. Would you agree that this is a specific characteristic of S21 that, as the accused said, it was daily monitored by the Standing Committee. This was not necessarily the case with other centers. When you talk about specific characteristics of S21, would it not be that these involved the permanent supervision or monitoring or constant monitoring of the Standing Committee?
Il faut bien se représenter quelle doit être la préoccupation de la direction
You must bear in mind the concerns of the leaders, this small group of 7 persons who led Democratic Cambodia. They were obsessed by the internal enemy. And you can see this in the case of an institution such as S21. So, Council, I would agree with you that this was a daily concern. It was constant. And it has, as has been said on various occasions, especially as the people who were taken to S21 as shown in the introductory submission, had 88 links with the Democratic Cambodia. 80% of them had this link. These were people at various levels of Democratic Cambodia. It was therefore normal that, unlike other security centers, the Standing Committee was particularly attentive in regard to S21, and especially as some of the members of that Standing Committee ended up there.
Vous seriez alors d'accord avec moi?
Could you then agree with me to say, then, that this proximity to the Standing Committee
ôte à Duch toute liberté de manœuvre?
Deprive Duch of any margin of maneuver. And this may be somewhat different from other centers that were more remote, where it was perhaps possible for the director of the center to have a greater, or not greater, but had a certain margin of maneuver. Is what I said a faithful representation of what we might consider the chain of command to be? The fact that Duch was so close to the Standing Committee that he had absolutely no margin of maneuver whatsoever. Could you agree with what I've just said? Answer.
J'ai envie de vous dire, maître, que personne
Well, Council, I'm inclined to tell you that nobody in Democratic Cambodia had any margin of maneuver, whether you be in Phnom Penh or in the outlying provinces. Perhaps there was some time lag for authority to come down given the distance. But I believe that in a system such as this, with squealing pushed to the degree where it was pushed, and pervasive suspicion, and I used the term earlier, even though I have no qualification to use it, paranoia, there is no margin of maneuver for anyone, whatever the function or the level in the hierarchy. Council, and yet Mr. Etchison came here and contended at the bar under oath that he considered that Duch had, if you will, an autonomy of decision, that he had been in a position to take some initiatives. What is your feeling about this? Do you think that Duch had an autonomy in decision-making? Answer. Well, if you have no margin of maneuver, you have no autonomy in decision-making. Why then would one read on so many confessions, annotations, which in fact are requests going to the higher authorities? If one had any autonomy in decision-making, one would not need to consult. As far as S21 is concerned, it's very clear that the decision on the ultimate fate of prisoners rested in the first place with the Standing Committee. It's very difficult for me to conclude on the basis of what we have available that there was any room for anyone to take initiatives or have any autonomy in decision-making. Now, I know that the statutes of the Communist Party of Kampuchea invite members to be creative and display imagination, but they say so many things that didn't occur in reality. If you read the statute and bylaws of the Communist Party of Kampuchea carefully, then you have eloquent statements about proletarian internationalism. I seriously doubt that a careful observer of democratic Kampuchea could find any trace of proletarian internationalism there. It's basically the bylaws of the Communist Party of Kampuchea is a little bit like the constitution of the Union of Soviet Socialist Republics. From the point of view of constitutional documents, it was a beautiful document, and we know what the reality was there as well. Council. Please correct me if I'm wrong, but I seem to have read that this creativity could only be applied in line with the party. Is that correct? Interpreter corrects, along party line. The party line, Council, was the only one that counted. There was no possibility to wander away from party line. And who defined party line? Except those who were members of the Standing Committee of that party. Question. Now, sir, you've surely understood that the co-prosecutors and the civil parties are attempting to attach great importance to S21, give it a particular level of specificity in comparison to other centers in order to justify the fact that Duch is alone amongst the accused on this issue. So it would appear to have been a very important center, and yet you would agree with me to say that Duch was not an army general, that in the military hierarchy he was at best a commander. This is what he says himself, and I don't think you found any trace anywhere of a more important role in the hierarchy. And he defined himself, when he was asked these questions, by stating, well, as a matter of fact, I was the faithful dog of the party, which is closer to the rank of commander than to that of general. Can I indeed consider things to have been that way? Answer. Council, perhaps if I speak in jest, I would like to say that I have too much respect for dogs to assimilate them with the function of the accused. A faithful dog is a very precious thing, and many blind people are aware of this. And I believe that, in effect, a center director, be that an important center, and no one can deny that S21 was an important center, if only given the quality, functions, or titles of those who went through that center and died there after terrible suffering. but it is also a characteristic of this system, of this regime of democratic Kampuchea. And I said this insistently this morning when alluding to what was happening in the Soviet Empire. No one was safe. And if no one is safe, apart the ones making the decisions at the highest level, everyone else is carrying out orders with zeal, more zeal or less zeal, being careful always to avoid being in the next group of people to be taken away, but always executing orders.
Monsieur
Génard,
plusieurs dans cette enceinte
many in this chamber
à Duch
have reproached Duch for not having resigned.
un grand sujet
This is a considerable issue
reviendra dans
which arose and which I imagine will return
reviendra dans les plaidoiries des parties civiles.
in the submissions and pleadings of the civil parties. He stayed in his position. From what you know about that period,
Que pouvez-vous nous dire sur la possibilité
what can you tell us about the possibility
de déserter son
that
poste
one had to resign or to desert one's post? Do we have any instances of that occurring? What can you tell us about this? Answer.
Le co-procureur
The
tout à l'heure
co-prosecutor
a bien voulu rappeler que mes travaux
earlier was kind enough to remind us that my work is basically focused on post-79. The royal government of Cambodia is constituted by someone who was one of the first to rebel against the regime of democratic Kampuchea and managed to escape to Vietnam. As it happens, the prime minister at the time was 5 kilometers away from the Vietnamese border, and one can well imagine that it was easier to flee to Vietnam when you're 5 kilometers away from the border than when you're in Phnom Penh. One should know, perhaps this wasn't said yet, that it was prohibited for inhabitants of democratic Kampuchea to freely travel the country, and one didn't have an automatic authorization to travel throughout the national territory. When worked in Phnom Penh, one had authorization to travel within Phnom Penh or in a zone, within the zone and not beyond it. And one should also know, and this is stated in the documents that have been filed, that any attempt to leave the country was subject to execution, to the death penalty. And one should also know that, depending on the period that you are considering, but it is important to recall this, fleeing to Vietnam was not without risks, because prior to a real state of war occurring between democratic Kampuchea and Vietnam, Vietnam pushed back into Kampuchea those who were attempting to flee, those who were seeking refuge. Now, this tapered off towards the end of 1977, a little bit before the break in diplomatic relations. But in 75 and 76, beginning of 77 even, fleeing to Vietnam was taking the risk of being deported back and executed instantly. And so it wasn't easy to consider fleeing the country. It was easier, admittedly, if one was near a border of the country, particularly Thailand. As we know, a certain number of Cambodians were fortunate enough, I may say, to be able to flee to Thailand, including during the democratic Kampuchea regime, but it was a small minority, so this wasn't without risks. Now, secondly, even though this did not apply in all cases, but it was said repeatedly and hasn't been challenged, when democratic Kampuchea struck, it didn't only strike the person considered to be guilty or responsible, but the wife and the entire family. Therefore, the repression exercised against someone who might flee or desert was a major risk, and the major risk was in fact that the reprisals would be exercised against the family, and that could be a major incentive to not leave the country. So we're entering difficult territory here, and this was the meaning of the last words I said in my introductory statement. Faced with this horrible choice to obey, and obey to the extent of killing others in order not to be killed oneself, who could today say with an easy conscience that they would sacrifice themselves? This is a question which every one of us sees lurking without ever being able to give a general answer to it. Council, one last question. So you referred us to the last sentence of your presentation of this morning. Well, let me refer you to the beginning of your presentation, where you expressed your sympathy and compassion for the victims. You worked in Cambodia toward a restoration of peace. And my question is of a dual nature. First of all, do you believe that the fact that for the first time a former Khmer Rouge cadre publicly recognizes his responsibility in this chamber, do you believe that this may help reconciliation? That's the first part of my question. The second is perhaps more difficult, in that the civil parties are in a legitimate quest to understand and to know everything that occurred. I told them from the outset that they would not be able to acquire knowledge of everything, first of all because Duch is not aware of everything, and secondly because how can one expect a human being to explain that which is inhuman? And therefore, I think that we will only get parcels of the truth. And this is where my second question joins the first one. Do you believe that even if this trial does not bring out all of the answers to all of the questions, do you believe nevertheless that it may help foster reconciliation? And I want everything to be clear here. I'm not speaking of forgiveness for something that is too intimate and belongs to the victims. I am speaking here about social reconciliation. Answer. I was amongst those who, along with the Cambodian authorities from 79 to 91, did not cease to request justice for the victims which had been refused at the time for over 10 years by the international community because, and you know this as well as I do, in the peace agreements, there was prohibition of the use of terms such as crime against humanity, breach of Geneva Conventions, or genocide. And that all that was mentioned, and I quote, were practices of a recent past. Therefore, I was amongst those who was pleased when in 1997 the first government issuing from the peace process, the two co-prime ministers sent a letter to the Secretary General of the UN requesting the assistance of the United Nations in order to try the main leaders and those most responsible in democratic Kampuchea and responsible for crimes against humanity. I was pleased with this, even though it took quite a long time to establish these chambers, because I believe that this country needs to know, at all levels, needs to know that justice is done. But as I said earlier, to judge is to understand and to explain, and you're right, Council. It is also these proceedings are also the victims of the regime of democratic Kampuchea and its secretive nature. We will never get to the bottom of everything. But what seems to me to be capital here and important is such that it must contribute to reconciliation. Pacification of the country did not occur through the decisions of the United Nations. It was achieved through the royal government of Cambodia in difficult conditions, but it has occurred. Something that neither the Vietnamese, nor Aung San Suu Kyi, or even the United Nations were able to do. The royal government of Cambodia has managed to achieve. This pacification rather than reconciliation remains vulnerable. It must be protected. But I remain convinced that the proceedings engaged before these extraordinary chambers may well contribute to this insofar as there will emerge in public opinion, and more specifically the Cambodian public opinion made up of survivors, if it leads to the emergence of a feeling that it is part of this necessary reconciliation. Cambodians have suffered too much. Far too much. It is necessary now to settle the issue of the past in all fairness and justice, and you're right not to mention the issue of forgiveness, because this is an individual feeling which goes to individual survivors, in terms of victims, but I think it is essential for Cambodia, and I think particularly to 60% of Cambodians born after 1979, once accounts will have been settled with the past, they will be able to confidently turn towards their future. Question. And according to you, the fact that the accused is the first Khmer Rouge cadre to publicly recognize his responsibility, according to you, this may assist in building this future? Answer. Counsel, I would like to ask you not to put this question to me. This is a question which only Cambodians can answer. It is my wish that it would help. It is my wish that it would contribute to gaining an understanding and to explaining and to turning the page. We have seen, well, I was a bit too young perhaps, but in the Nuremberg trials, we saw a majority of Nazi leadership rejecting any responsibility, and then one of them break ranks and accept such responsibility. I believe that recognizing responsibility is making headway, is making a contribution toward reconciliation. This does not exclude, this does not remove responsibility and what it implies, but it contributes toward reconciliation. And from that point of view, my wish would be that the example set by this accused be followed by the other main leadership of the Khmer Rouge in the country. They owe us this, given the suffering that they have inflicted. Mr. President, I have no further questions. The defense thanks you, sir, for having come to the bar.
The President, next, the Chamber would like to give the floor to the accused if he so wishes to make any observation in respect of the testimony of Mr. Jinnah. And at the same time, if he wishes to make his observation in relation to the testimony of Justice Richard Goldstone, then he would do so simultaneously. The accused. Mr. President, good afternoon, Professor Richard Goldstone from a distance and Mr. Jinnah, who is here in the courtroom. I am very grateful to both of you for your testimonies that enlightened me on the nature of the work I done. I have nothing to contest their testimony, but my thankfulness to both of them. That's all. The President, the proceedings to hear the testimonies of the experts and Mr. Raoul Mark Jinnah comes soon, and the defense counsel interrupts. You take the floor.
Forgive me, Mr. President, for a question related to procedure. I would like that there be filed in our debates the consultation of Mr. Jinnah, which is at reference D80/5 of the investigation file. And we would also like, excuse me, D82, sorry, D82. We would also wish that there be put on record the book of Mr. Jinnah, Les Clés du Cambodge, Keys to Cambodia, which is found at reference D80/5, as well as all the other documents that I mentioned earlier. Thank you, Mr. President.
The President, the prosecutors, would you make any comments in relation to the documents being put by the defense counsel, although they are already in the case file? Prosecutor, thank you, Mr. President. The co-prosecution, the national co-prosecutor has nothing to contest this submission of the documents before the court. The President, the civil party lawyers, would you wish to make any comment in relation to the documents as raised by the defense counsel?
We have no comments to make, Mr. President. Thank you.
The President, thank you. Mr. Raul Chenach, the proceeding to hear your testimony has come to an end. The court is very grateful to your attendance. And we appreciate your time, of course, as a witness, and you turned up as called. Now, the proceeding for today has already come to an end. The trial chamber would like to adjourn the hearing now, and we resume the session tomorrow at 9 a.m. The security personnel are now instructed to take the accused back to the detention facility and bring him in by 9 a.m. The court is adjourned.
សូមអញ្ជើញក្រោកឈរ
The President, please be seated. The court is now in session. Judges of the bench, would you wish to put questions to the expert? You take the floor, Judge Lavergne.
Oui, monsieur l'expert, ce que j'ai entendu ce matin,
Mr.
c'est que
Jana,
vous
what I
aviez
heard this morning
l'occasion
was that you had the opportunity to conduct a number of interviews with the accused.
Vous nous avez parlé notamment des sources.
You told us, amongst other things, of the sources of ideological inspiration of the Communist Party of Kampuchea.
Votre rapport a également été discuté avec l'accusé lui-même.
I'd like to know whether you discussed this part of your report with the accused. In particular, you talked about the culture of violence that pervaded this country. We have had to put questions regarding the political violence that the accused may have experienced. Did you deal with this when you talked with the accused? And could you tell us what the accused said about this?
Merci, Monsieur le Juge. Effectivement,
Thank you, Your Honor.
beaucoup échangé avec l'accusé sur
I talked with the
les
accused
sources
at length
idéologiques
on the ideological
du régime
sources
du Kampuchea
of the
démocratique.
Democratic Kampuchea regime, but I did not talk
la question de la
specifically
violence et de la
about
violence
the
politique.
issue of violence
Ce
and
que
political
j'ai
violence.
exposé ce matin, c'est plutôt le résultat de recherche
What I
historique
discussed this
sur
morning was
la
the
période
result
qui
of my
commence
historical
avec
research
l'indépendance du pays en 1953.
of the
Je n'ai pas
period beginning with the
expressément
country's
évoqué la
independence in
question de la violence
1953.
politique
I did not
avec
specifically
l'accusé.
discuss the issue of political violence with the accused.
Il ne vous a jamais dit que que la
Question.
violence politique était quelque
So,
chose qu'il avait accepté
he never
comme faisant
told
partie
you
du combat,
that political violence
comme
was something he
étant
accepted
inhérent
as part
à la
of the
politique
struggle,
PCK. Vous n'avez pas abordé du
as
tout
being
cet aspect.
inherent to the policies of the
D'accord.
Democratic Kampuchea Communist Party. George Laveng continues. All right.
Excusez-moi. Je ne peux pas,
sorry.
rapporter des propos qui ne m'ont pas été tenus.
I cannot report what was not
Même si
said
on
to
peut
me.
avoir sur
Even
la
if
place de
it
la
is
lutte armée
possible
dans le combat communiste classique, une
that
opinion, ça n'a pas
one
été
might
évoqué
have an
et nous
opinion
n'avons rien.
on the communist struggle. This was not mentioned specifically.
Alors, on a beaucoup parlé également donc,
Judge
ce matin
Laveng,
des sources. Vous avez
this
parlé,
morning
je
there
dirais,
was a discussion of
sources
sources.
françaises,
You
de
talk
sources
about
soviétiques.
French and Soviet sources.
Ce qui m'intéresse un peu, j'aimerais que vous développiez un peu plus
I would like
le
you
problème de la source
to
chinoise.
develop the
Parce qu'il me
issue
semble
of the
qu'on
Chinese
n'a
source,
pas eu
because it
beaucoup
seems to me
d'explications.
that there was
Or,
not a great deal of
il
explanation
me
in this
semble que,
regard. And yet,
l'accusé, de par son histoire personnelle,
it seems to me that based on what the accused has said and his personal history and what he said about his pride in seeing China being the spearhead of a major revolution, this may have contributed to restore the image of the Chinese. Did you discuss this with him? For example, do you know what sort of books the accused may have read or not?
Effectivement, on a un peu abordé
It is true that
la place de
we
la Chine dans
did discuss the role
la formation idéologique
of
de
China in the
l'accusé.
ideological training of the
Mais comme vous
accused.
venez vous-même de l'indiquer, je crois
As you
que
yourself have just stated, however, I believe
ce que l'accusé percevait surtout,
what the
c'est cette
accused
espèce de
perceived
restauration
was,
de
above all else, this
la fierté nationale
restoration,
chinoise
as it
d'un
were, of
pays qui
Chinese
avait
national
été,
pride, the restoration of the
pillé,
pride of a
découpé
country
en morceaux
that had
par,
been pillaged
par
and
nous les Européens,
partitioned by
et qui
us
retrouvait,
Europeans,
avec
and which,
la victoire du Parti communiste
with
chinois et
the
de Mao
victory of the
Tse-tung,
Chinese
une
Communist
certaine
Party of Mao
dignité, une
Tse-tung,
certaine fierté nationale.
was regaining a sort of
Cet
national
aspect-là, il a
pride.
mentionné des ouvrages,
He mentioned
notamment des
works
ouvrages
in
de
that
Mao
regard,
Tse-tung lui-même,
particularly the works of Mao Tse-tung
mais d'autres
himself,
aussi,
and
mais je n'ai pas eu
others.
le sentiment que c'était
But I did not
constitutif
get the feeling that
d'un comportement.
this had
J'ai pas eu le
informed his
sentiment, en tout cas,
behavior.
que,
In any event, I did not feel
ces lectures
that
chinoises, je vais dire,
his reading of Chinese
aient
works,
contribué
if one may put it that way,
conforter, sauf
contribute
pour l'adhésion d'une manière globale, générale, au communisme
in any
au sens
way
le plus large du
apart
monde,
from the
mais
adherence
a
to
conforté
communism
ce qui
in
fut
the
son rôle
broadest sense of the term. So it did
comme,
not support his specific
exécutant
role
dans le Kampuchea démocratique.
as somebody who carried out orders in democratic Kampuchea.
Et en ce qui concerne
Question.
les événements que l'on qualifie
With
de révolution
with regard to the events
est-ce que
described as the Chinese Cultural
quelque chose
Revolution,
qu'il a pu aborder? Est-ce que c'est quelque
did he
chose
discuss
qui a eu
this?
une certaine importance?
Was this
Là, on se
important?
situe dans des périodes de temps qui sont quand même très proches.
These are fairly recent
On a
times
aussi,
we're
me semble-t-il,
discussing,
certains traits
and it
qui
seems
peuvent
to
être très
me
communs.
that
Donc,
there could be
est-ce
some
que c'est quelque chose que
commonalities.
vous avez abordé?
Did you discuss this?
Il y a des habitudes qui sont difficiles à prendre.
Mr.
excusez-moi.
Jenner, I'm sorry, there's some habits
La
that are
révolution
hard to
culturelle chinoise
adopt.
a beaucoup marqué les
The
esprits,
Chinese
au
Cultural
Cambodge. Il y avait
Revolution
une
was
association de
of great
solidarité,
influence in
Sino-Khmer,
Cambodia. There was a
dont
Sino-Khmer
d'ailleurs un
Solidarity
des
Association,
futurs ministre de Pol Pot et aussi une des futures victimes des 21, Hunim,
which included Hu Nim, one of the future ministers of Pol Pot and one of the victims of S-21. He was prosecuted by Sihanouk for distributing Mao's Little Red Book during the Cultural Revolution. But it is not my personal feeling that the events of the Cultural Revolution, apart from the fact that they supported the motivation and membership in communist organizations, supported the Cambodian communist struggle. Apart from that, I do not think that it was a decisive influence in what became democratic Cambodia. Apart from, as I said with reservation, certain aspects of agrarian collectivism or rural collectivism, I said before that China never did go as far as democratic Kampuchea in terms of collectivization of rural farms, which is why I emphasized that they wanted to have a great leap forward, as Mao had done.
Ce matin, lorsqu'il a été question de l'influence soviétique,
with regard to the influence of the Soviet Union, there was, you mentioned trials. In my view, one of the characteristics of democratic Kampuchea was, in fact, the absence of trials.
Vous avez parlé du secret tout à l'heure.
You talked about secrecy.
On est, me semble-t-il,
It
dans des
appears to
procédures
me that
du plus extrême secret.
Any proceedings were conducted in the utmost secrecy. But the nexus between this Soviet source and what happened in democratic Kampuchea might be the confessions.
Ce que ici on appelle les confessions, ce
What
que
we call
ailleurs on
confessions.
appelle des aveux. Mais le terme ici, c'est vraiment le mot confession.
In the French, you use confession and aveu, but here in this court, it's confessions we use.
Avec l'accusé,
in your discussions with the accused,
à parler avec lui justement de l'importance
did you discuss
de ces
with him
confessions?
The importance of these confessions?
Monsieur le juge, je suis tout à fait d'accord avec vous.
I quite agree with you, Honor. There were no trials in Cambodia.
Souligner l'importance
I emphasize the importance in political training of young Cambodians in Paris, of the procedures that were used during these trials.
Construction de la personnalité.
And these were personality constructs which were devised by the interrogators. I suspect you know this quite as well as I do. Arthur London, in his book of Book of Confessions, as shown in the film that was produced afterwards, showed this. The important thing, in my view, is that they were seeking confessions, and we use the word confessions in Cambodia because the first researchers here were Anglo-Saxon and they used the word confessions. And I think they're referring to Santepip, the word in Khmer, if I am not mispronouncing this word with my poor accent. In any event, it was the same thing that was being referred to. It was a technique which was at the heart of what was done in the 196 security centers of Cambodia. They were seeking a statement from someone who had been found guilty beforehand in any event, so that they could justify their act and therefore so that they could use this confession against those who were the next on the list, if I may put it that way. Much has been made of this because it is a key element. And in fact, the accused himself said that his work consisted fundamentally of rereading confessions
que d'interroger lui-même directement.
rather than
Et c'est vrai,
carrying
quand on
out
regarde la masse de
interrogations
documents que ça
himself.
représente,
And when you look at the
il fallait y
volume of
consacrer effectivement
documents,
beaucoup de temps.
you will realize that a lot of time was needed for this. So that part of his role was reflected in our discussions. We talked about this at great length, and in fact, I did try to find out more. I wanted to find out who had taught him this technique so that he too could teach it to the interrogators. Because this was one of the sources of terror, torture. This was the ideological source. And Son Sen played a major role in this context, although he was not alone. Von Vet was also an instructor of the accused, but Son Sen played a preponderant role, which is why, with a little help, I tried to establish a link between what Son Sen did in Paris, what he learned in Paris, and what he did when he was the accused's superior.
Donc, lors de vos entretiens,
during your
est-ce
discussions,
que vous avez ressenti de la part de l'accusé la conscience
did you feel that the accused was aware that these confessions were used to lend weight
des accusations,
to
à des
accusations,
définitions d'ennemis qui
to
étaient
definitions of the enemy,
fournies par
which
le
were
centre
provided
du parti.
by the party
Et
center?
est-ce que même au-delà,
Beyond
est-ce que
that,
vous avez pu ressentir ou est-ce que l'accusé vous a
did you
indiqué
feel, or did the
qu'il
accused
avait
indicate
pu
to you
contribuer
that he had
à
contributed
développer ces définitions
to the
des
development
ennemis
of these definitions of the enemy of the, or the enemies of the party?
Très vite, l'accusé a indiqué
Answer.
qu'il
Very
ne
briefly, the
croyait pas
accused
que
indicated that
c'était
he did
par
not
les
believe
techniques qui étaient employées, c'est-à-dire la torture,
that
qu'on
it was
pouvait
through the
obtenir
techniques
la vérité.
such as torture that the truth could be
Mais qu'est-ce que
obtained.
c'est, la vérité?
That
Il
what is the
faisait,
truth?
il l'a dit à de multiples reprises, ce qu'on lui demandait de faire.
On
Alors,
numerous
a-t-il
occasions, he
contribué
said that he
à
did as he was
une
told.
formulation qui
Did he
convenait au
contribute
centre?
to the
Sans doute,
definitions
puisqu'il
which
réagissait
were
aux
useful to the
injonctions qui
center?
venaient du centre, qui
Quite
venaient
possibly,
du bureau
because
870, qui venaient
he
du comité
obeyed
permanent,
orders from
du comité
the
central.
Central Committee of
Il
the
insistait d'ailleurs beaucoup pour
party.
dire que c'était
Emphasized strongly,
conversation téléphonique quotidienne
and he used
avec Son
references
Sen,
to daily
que
telephone
c'était
conversations
sur
with
les
Son Sen,
instructions de
that
Son Sen,
these were the instructions of Son Sen,
il agissait comme il agissait.
and it is on these
Tout,
instructions
si je peux
that he
dire,
acted as he
tout
did.
son système d'explication
His
a
whole
consisté à
framework
dire
for
qu'il
explaining his
était
actions
relais
was based on
exécutant
the fact that he
d'instructions
was
qui lui
a
étaient
relay to implement instructions
C'était
issued to him.
particulièrement sensible lorsqu'il s'agissait de
He was particularly
décider,
sensitive with regard to
du sort
deciding
ultime,
the final
des victimes.
fate of the victims.
Il se référait, en tout cas dans les conversations,
In the
aux
conversations
instructions
I had with him,
Chaque
he
fois.
referred each time to the instructions he had received.
On a également parlé ce
Question.
matin de la
This
terreur.
morning,
Et
you also
j'aimerais
mentioned
savoir si
terror.
vous avez abordé avec
I'd like
l'accusé
to know whether
les relations, le
you
type de
discussed
relations
the
que
types
lui-même
of relationships
entretenait
that he
à
himself
l'égard
had,
du
that the accused
personnel
himself
du
had
S21.
with the S21 personnel. Did you
Pas du
discuss
tout.
this
Non,
with
pas
the
du tout.
accused? Answer, not at all.
Parce que au
Question.
cours des débats,
Because in the
il a
course of
été aussi
the
question,
proceedings,
des dénonciations.
the
On a
court
parlé
has
des
heard
dénonciations.
of
Vous avez dit que c'était
people being
une
reported.
pratique généralisée.
This was a widespread
Mais
practice,
Duch lui-même
it
a
would appear,
indiqué que
but Duch himself
il
said
dénonçait
that
ses
he
supérieurs
reported to his
les
superiors
comportements de ses subordonnés
the conduct of
qu'il
his
estimait
subordinates where he found that such conduct was contrary to that expected of a model guard or a cadre of the Communist Party. So you didn't discuss this at all, did you? Answer. I repeat that we did not discuss the relationship between Duch and the staff of the center. That said, it is but normal in such a system where reporting is the rule that he was part of the system. I studied the camp in Bon-Trabec where the diplomats were interned as well as students. There was a center director who was required to report to Office 870 and who was required to report bad behavior, defection, or poor attitudes of the staff and the prisoners. So this was a general system where everyone spied on everyone else, and whoever failed to do so might himself be under threat. But this is a personal deduction rather than a conversation or the result of a conversation with the accused. Question. This morning, we also discussed the racist background in the policies implemented by the Communist Party of Cambodia, the CPK. Did you discuss this with the accused? Or did he tell you that he was aware of these problems? Did he tell you whether some of the S-21 detainees were detained on racist grounds?
Non.
Answer, no.
On a évoqué la présence de
We
prisonniers
discussed the presence of Vietnamese prisoners
liés à la situation
in connection with the situation of the relationship between the two countries,
l'aspect du racisme.
but we did not discuss racism.
Si je peux me permettre
If I may,
d'être un peu libre dans mon expression pour être en
speak
contact
more
avec le Cambodge
freely,
depuis 20 ans.
because I've been in contact with Cambodia for 20
Personne
years
ne
now.
peut nier
No one can
que
deny
lorsque l'on parle
that when
des Vietnamiens au Cambodge,
reference is made
on
to the
entend
Vietnamese
un
in
discours d'une
Cambodia,
tonalité qui n'est pas toujours
one
très
hears in
fraternelle.
response
Et donc, c'est pas étonnant,
something that is not
de ce point de
very
vue-là,
fraternal. So
on n'entendra pas
it is
quelque
not
chose de
surprising
différent de la bouche
that
de l'accusé, de beaucoup
one might hear
d'autres,
something different from the accused
Cambodgiens. Il y a
than from
un
other
petit peu de ce que nous avons
Cambodians.
connu en Europe. De la
There is a
manière
little
dont
of
les
what
Français
we
pouvaient considérer les
experienced
Allemands et les Allemands considéraient
in
les
Europe.
Français,
You know, the way the
avec
French
des
viewed the
intensités
Germans
qui
and the
ont
Germans
ici,
viewed the French
mais chez nous
with
aussi, en d'autres
degrees
temps, étaient dramatiques.
of feeling that have led to disaster on some
Alors,
occasions.
je voudrais enfin aborder un autre problème.
Question. I'd now like to move on to another problem,
Ouais, me semble-t-il difficile, celui de
a
la
somewhat
place
thorny
de
issue, which is
S21
the
parmi les
role
autres
of
centres de sécurité.
S21 as compared to other
On sait
detention
que
centers.
il y a eu de nombreux centres
We
de
know
sécurité
that there were many
dans
security
le
centers
Cambodge.
in
Ce que
Cambodia.
j'aimerais que vous nous indiquiez,
What I would like you to tell the
c'est
court
si, selon vous,
is whether, in your view,
est un centre
S21
qui revêt
was
certaines
a
spécificités
center with
qui en
some
font un centre
specific characteristics that set it apart from the others,
comme je l'ai lu
or
dans
whether,
votre note,
as I read in your note,
c'est un centre parmi d'autres
it was just one
dans un
center
système
like
général
many others
d'élimination
in
planifiée.
a generalized, in a
Alors,
general system of
si la
planned
spécificité de
liquidation. So if there are any peculiar characteristics of S21, what are they? What can you tell us? I should add that in your note you said, in reference to documents not attached to your paper and which are not in the record of the case, that S21 was not at all the principal place where exterminations were conducted.
S21, j'ai envie de dire qu'il y a une spécificité subjective et une
I think
spécificité
there is
objective.
an objective and a subjective peculiarity to S21. Subjective in the sense that since S21 is in the country's capital, and because from 1979 it was transformed into the Genocide Museum, to use its title, because that's where the journalists go, and this is where attention has been drawn the most, forgetting that at the beginning there was not much about S21. It only came after the research of DC Cam, which highlighted the number of other security centers, but there is an objective peculiarity because unlike other security centers, in S21, victims included people coming from all over the country. These were people who, when they arrived in S21, had been sent there by the Standing Committee of the Central Committee. So there's peculiarity with regard to S21. I did mention it a while ago. It was in S21 that in varying proportions, but in a majority, where we found cadres of various levels of democratic Kampuchea who had come from all the provinces or the zones, to use the terminology at the time of the country. That said, it is still a little difficult to discuss something that involves huge suffering and death. It's like a classification of horror. It remains true, however, and this is what I was referring to in my quote that you referred to yourself, that there were other security centers in democratic Kampuchea, or at the very least, there are reservations with regard to the counting of the bodies or skeletons as they have now become. There were larger numbers of victims than in S21. It doesn't mean that anybody is innocent. I will tell you frankly, if you will allow me, that it is not only the accused who should be accused as the head of a security center. All we need to do is to find other heads of security centers who are still alive today. And many of us do know that some of them are still alive and they are living peacefully, whereas apparently they were heading security centers where there were a large number of victims and sometimes a lot more than in Tuol Sleng.
Alors, est-ce que parmi les spécificités de S21,
now, amongst the specificities of S21, is there perhaps one related to the fact that S21 had several branches, the Tuol Sleng branch, but also the one called S24? And if you can reply to this question, was it the case that all the security centers were made up of several branches, or were they differently organized? And another question, do you know, are there reliable statistics, more reliable than those about the number of persons who were killed, reliable statistics that would enable us to find out how many persons were employed at S21? Do you know how many people were employed at S21?
Les éléments auxquels vous faites référence, à savoir
Well, the elements you're referring to, the fact that there were several divisions or sections or branches like S24 and S21, was part of what I would call an objective specificity. That's clear, and staff, even if it did vary, according to current knowledge, it's a bit difficult to give figures, because when you have figures as apparently accurate as what is put in the S21 case, and even if the former director of S21 was a very exact and cautious man, meticulous man with Israel, but nevertheless, with regard to S21, apparently, because research was not carried out with the same degree of intensity in the other centers, particularly those where we think that there were far more victims than in S21. But apparently, out of intellectual loyalty, it would appear that there were fewer staff in other security centers because they focused less, inter alia, on confessions. So this is an argument as well, because we found no confessions elsewhere. But it should be said that according to the statements of the accused himself on the eve of 1 January 1979, Khieu Sampang said, "Don't worry, the Vietnamese will not enter Phnom Penh," and that this is one of the main reasons why the records of S21 were not destroyed. There was much more time in the other security centers of Cambodia to destroy such records. So I would be more cautious than others to say, well, since there are no records elsewhere, there was probably less of that taking place. I think that here again, there is a field of investigation for research in order to establish the exact scope of the phenomenon of physical elimination as a method of government. Thank you very much, sir. I have no other questions for the expert.
The President, next the Chamber would like to give the floor to the co-prosecutor to put questions to this expert. The co-prosecutors have 15 minutes. Co-prosecutor, thank you, Mr. President. Good afternoon, Mr. General. I have some questions for you. This morning, and just then, in your response to Your Honor, the strategies used by the leaders during the Democratic Cambodia regime, based on your research, would you be able to tell the Chamber the strategies or approaches used by the CPK during that time? Were they copied from other communist countries, especially from the former Soviet Union, from the Lenin, Stalin, or from China, or from the Cultural Revolution in China, or from Vietnam?
Si j'ai bien compris, Monsieur le procureur, quand vous
If my understanding is correct, Mr. Prosecutor, when you use the term which is translated as strategy, you're talking about the project that was implemented.
The co-prosecutor, would you please repeat your statement?
Dans la traduction en français de votre
Well, in the French
question,
translation
on
of your
utilise le mot
question,
stratégie.
the term strategy was
Je voudrais savoir
used,
si ce
and
qui signifiait par là
I
le projet
wanted to know
politique mis
whether
en
what you meant by this was the political project that was implemented.
The co-prosecutor, I have problem with my earphone. What I said is in reference to your report at section 5, you talk about the strategies used by the CPK. The CPK inaugurated and implemented the use of such strategy, and you talk about the former Soviet Union, about Lenin and about Stalin. So my question is, the strategy implemented during the Democratic Cambodia, was it cloned or copied from those communist countries?
Je l'ai dit dans mon propos introductif ce
Well,
matin.
as I said in my introduction this morning, and this has been confirmed in numerous writings, Democratic Kampuchea wanted to reach ideal communist society in a single leap without any transition. And we have writings in the archives of S21 and the records of this determination to do better than the Soviet Union, better than Lenin and Stalin. Because for those who follow their thinking, in fact, the leaders of Democratic Kampuchea think that they almost betrayed, and they were almost traitors, and the determination to do better than Mao's China. So there was some sort of irrational dimension to this determination to outdo everyone in the communist world. Whatever their political house, better than those who were following Beijing, better than those who were following Moscow. This will to achieve excellence in a system which obviously, and I said it and I emphasized this a lot, took no account whatever of the human cost in this vision of the revolution. No transitional margin was calculated in to this project. So with regard to party organization, security apparatus, I have tried to show that as far as I am concerned, the inspiration comes more from Stalin, is more Soviet in nature, even though there was certainly an attempt here to implement a rural or agrarian collectivism that was absolute. Here the connotation is more Chinese. But once again, by going farther than that, in China, rural families were not dismantled. Collectivization of land was not carried as far in China as it was in Democratic Kampuchea. This is the specificity. This is what I call the specificity of Pol Potism. This will to go faster, farther than all the others in the edification of what they called communism without any account or consideration given to human life.
Thank you, Dr. Jenna. My second question. Based on your research, can you respond in brief? The cruelty and the barbarity during the mass killing, torture, and the administration system in various detention centers, particularly S21 Center. Were the mechanism similar or were it special compared to this sort of system implemented in various other communist countries?
Pour ce qui est du fonctionnement d'un centre de sécurité comme celui des
Concerning the operation of a security center such as S21, the determination to extract from prisoners what was called confessions or aveux in Europe, in Eastern Europe in particular, but also in Russia and the Soviet Union, I see no major difference, except what I mentioned to Judge Laveng, the fact that there were trials taking place, but trials which are far removed from the vision one has of public justice and adversarial justice in a democracy. It was staged. This is what happened. In the Soviet bloc countries, the trials were staged. The objective was to extract a confession, to achieve the depersonalization of individuals, their humiliation, and in a manner which was certainly less systematic in the Soviet Empire than was the case in democratic Kampuchea. Capital punishment practiced on a very large scale, and I've alluded to this in Budapest and Sofia. Scores of persons were sentenced to death, but the proportions cannot be compared. In engaging horror, democratic Kampuchea also practiced a single leap approach.
Co-prosecutor, thank you. This is my last question. Can you respond briefly because we are on time limit? Do you think the national reconciliation can be achieved? And if there were an amnesty or pardon for the accused here, would it be possible? Can you respond briefly?
You're asking me to give a short answer to a question that is very difficult and sensitive. And in all honesty, I believe that I can't say yes or no in answer to your question. Neither can one use a brief summary response. There are many people who are survivors, who have suffered, who carry with them a grief and pain that is far from being over. And there is a need. This country needs peace as much as it needs a rise. It needs to turn toward the future. So we see objectives that are sometimes contradictory, and I'm afraid here that I'm going to fall outside of the framework of this trial and speak of Cambodia, contemporary Cambodia, and it's not my role. But having witnessed operations where Khmer Rouge units rallied the new government in the 90s, I would be tempted to say that reconciliation is a process that must not leave justice by the wayside.
Co-prosecutor, thank you, Dr. Jenna. Thank you, Mr. President. My colleague will take the floor.
Merci, Monsieur le Président.
Thank you, Mr. President. If you will allow me, I have a few questions. seem important to me for the witness, and it may be the case that I will speak a little bit beyond the time that we've been allotted, but since we went rather fast this morning, I would like to beg the Chamber to allow me to go to the end of some of my questions, particularly with regard to the role of S21 in the Santebal. But before doing this, I would like to clarify something, sir. I've read some of your writings, articles, and books that you've written about Cambodia, and you've written essentially from the point of view of political analysis. First of all, I would like to know if you carried out research of an historical nature on a large scale with regard to, or concerning rather, democratic Kampuchea, or if you referred mainly to books already written by historians or research already in existence. But it seems to me that you've concentrated more on the contemporary era in Cambodia from 1989 on, which is when you came here. So could you tell us about your research with regard to democratic Kampuchea? Well, I won't argue the fact that I worked a great deal more on the period following 79 than on the 75 to 79 period. Nevertheless, and it was mentioned earlier, with a historian called Ben Kiernan from Yale University, I was a member of the Scientific Council, which was the prelude to the creation of DC-CAM. And in this capacity, I took part in research work, particularly in those areas that were discussed with Judge Laveng, the racist nature of the political positions of democratic Kampuchea. Prosecutor, thank you. More specifically, did you carry out specific investigations of Santebal and the role of S21 inside the security apparatus of democratic Kampuchea? And if so, did you publish this? Perhaps I did not see some of the publications that you have made.
Je n'ai pas publié sur ce sujet.
Well, no, I did not publish anything on the subject. However, within the same and working within the same team, at a time when information was far more scarce than today, I'm talking about the 80s and the 90s, with a team located in the United States, we tried to identify a certain number of elements which could be translated today in the determination of the chain of command of the security apparatus, and I did work in this framework. Prosecutor, thank you. In your written contribution, as Judge Laveng said earlier, we apart from general mentions of sources, we didn't find any footnotes that would support each one of the arguments and conclusions that you shared with us. However, you're an analyst, you're a professional researcher, and I'm a bit surprised by the method that you employed. Could you explain to us why you made this choice, which prevents us from verifying the facts that you mention in this contribution? The witness. Oh, I understand your question quite well, and when I see a text which is not supported by references, I'm the first to regret this. But I did what I was asked to do. I was asked to prepare a 150-page study. Had I been asked to do a 150-page study with 40 pages of footnotes, I would have done it. But in fact, I was asked to prepare a short document which contained the essential aspects of what I felt deserved to be mentioned, and which we came back to with Judge Laveng. I'm perfectly aware of the fact that such a document is weak in the eyes of someone who needs convincing, but I did only what I was told.
Je pense qu'on peut vous donner l'occasion de vous rattraper si c'est possible.
Well, perhaps we can give you the opportunity to make up for this, if possible. Could you give us the list of your sources which would enable you to conclude that the 196 security centers listed by DCCAM, which you refer to, and I quote, are split into 4 categories. Each type of center is based on the authority of the corresponding administrative unit, without any hierarchy between these different levels. This is your document T82, page 7 of the French. Now, can you tell us what source you relied on to come to the conclusion that there was no hierarchy between these security centers? The witness. Well, the sources are the DCCAM documents. All the research I carried out on this is based on DCCAM. I can't give you the reference numbers of the documents from memory. I'm sure you can understand that. But these documents are in the archive and documentation repository of DCCAM, and along with research already performed by other researchers, and particularly one describing the chain of terror, which is quite explicit and deals with only one area. Now, it's on the basis of that research that I concluded that I did not perceive that there was a hierarchical link. Of all the figures that we have, I recall 196, maybe there were more, but we see no hierarchy between the different security centers. They fundamentally all have the same function and the same role, as I said to Judge David before, the specific features of S21, for instance, as I said, the possibility to take into custody and then to interrogate. Basically, S21, the main difference with all the other centers, had in fact jurisdiction over the whole country. Now, I cannot say that this created a hierarchical link that placed S21 above all the other security centers. It is true that in S21 you will find persons whose responsibilities in the system came at a much higher level than the victims of the other security centers. But once again, apart from moral importance, from the point of view of an administrative grid for a security system, it did not place it in a higher hierarchical position. Prosecutor, thank you. But in your consultation, you did state that in democratic Kampuchea, the administrative structure was highly hierarchical, and you mentioned 4 levels precisely for the security centers. Those that were created at district level, at regional level, at zone level, and one single one which you mentioned at the level of the Central Committee, and that is S21. Does this not tell us that there is a hierarchy between the security centers, a hierarchy which is in parallel with the power structure of democratic Kampuchea? Well, in order to be able to state this with complete certainty, we would need to have in hand, which I believe we don't have, traces of transfers from a district center to a regional center, for instance. Whereas what we know, on the contrary, and this is stated in a document dated 30 March 76, there is a district-level responsibility, a zone-level responsibility, and each time it is at that level without any link or communication, if I may use the term. So this is what leads me to think that there was no real solid hierarchy. Prosecutor, if I go back to the example quoted by Mr. Van Nat, who testified here, if you know his story, he was arrested in a cooperative in Balat, where he was detained for a short period of time. He was then transferred to the Sector 4 security center in Wat Saffron for one night. Then he was transferred to Wat Ganal in Batambag City, which was the zone security center, and then finally, after having been detained in that location for several days, he was transferred to S21. Does this not give us a clear idea that people who were arrested were either interrogated and executed on the spot or were transferred towards the Central Security Center if that person was considered to be of importance? And would you have any contrary examples where persons may have been arrested towards the center and sent to peripheral security centers in the districts or in the zones from the center? Answer.
L'hypothèse du contre-exemple que vous avancez n'est pas vérifiée dans les faits.
The hypothesis of counter-example that you mentioned is not verified by the facts. I can't say either that what happened to Mr. Van Nat was current practice. Many of the people who came to S21 came directly. Perhaps they stayed overnight in a local district or regional security center. Nevertheless, they were headed for S21. Prosecutor, how can one explain then that in S21 we found not only 155 persons, according to certain lists that were produced, 155 persons who were members of S21 and were arrested within S21 and executed on the spot, but also other staff and cadres from other security centers in the rest of the country. In fact, it's the accused who drew up a list of 40 names of persons who came from other security centers in the country from all these zones. How can you explain that they ended their life in S21? And as far as we know, no member of S21 staff was ever sent out to some of the other region security centers. Answer. As far as those in charge of other security centers are concerned, I alluded to this morning. To me, it's simple. The decision to send them to S21 was based on a standing committee decision came from the center, and that's what made their transfer to S21 so specific. Question. Mr. President, I would like to return to the conclusion of the expert witness this morning. After having spoken to us at length about the influence of communism and Stalinism and the thought process of future leaders of democratic Kampuchea, at the end of his statement, the expert concluded by saying that he agreed with the fact that Duch could be both a perpetrator and hostage. Now, I didn't fully understand what this conclusion relied on, whether it was the logical conclusion of everything that you had explained before, or whether something else came into play which you didn't specifically mention. But I would like to draw your attention to three elements among several others and hear your comments. The first, you said earlier that a certain number of persons had answered the call of Prince Sihanouk to go in the jungle and join the Funk. But Duch did not go into the forest or join the CPK as a result of this appeal. He was in agreement with party ideology. As he said, he was ready to sacrifice his life for the party. And you also recall that when one became a member, one had to be aware of a series of fundamental principles, which he was therefore aware of, and he was also familiar with the radicalism of the CPK and came to know a certain number of his leaders quite early on. So we can't say that he was taken by surprise like the Sihanoukist who had joined the Funk. And in fact, we believe that he shared this ideology as well as the consequences of this ideology, and in particular the armed struggle, which wouldn't really necessarily make him into a hostage, but rather into a participant. Now, secondly, you have the question of the terror, which you mentioned. Of course, one can say that this terror was extended to all Cambodians, including those who participated in the regime. But is it not also true that the accused vastly contributed to this terror by his creativity, by his action in M13S21, development of certain methods of torture, which were the result of his own past experience? And the last element I would like you to give us an answer to is, how can one explain that if he was really a hostage, once the Vietnamese took the city, the capital city in 1979, why did he continue to be a committed member of the Khmer Rouge for nearly 20 years? Whereas he may have had an opportunity, had he lagged behind, to take advantage of the chaos of the debacle to part ways with his companions. When Luc de la Pentailleur interviewed him in 1999, when they discovered him, he was still with the Khmer Rouge, even though Nuon Chiak, Khieu Sampang, and of course Ieng Sari before him had gone to Phnom Penh already at the end of 1998. So it is the length of his commitment. Can you really say that this is representative of someone's status as a hostage?
Answer. Thank you. I did not say actors and hostages, it was servants and hostages. That's what I said. With reference to your first point, that is whether it is not debatable that there is no debate on the fact that the accused was a member of the party and that he was part of a system which, as I have said, was in the shadows, or was in the shadow of President Norodom Sihanouk of Funk. There was no surprise element. I have trouble accepting that the accused contributed to the development of new methods of torture, which those that were used in S21 were well known before, and even before M13. They were by no means new. They had been used. They were used in the prisons of Norodom Sihanouk in the 50s and 60s. Did it contribute to the terror? Of course they did. Any system that uses methods such as these feeds terror. With regard to your third question, I don't think it's as simple as that. We know that on the 7th of January 1979, thousands of people were taken by retreating Khmer forces to the Cardamom Mountains and the Thai border, amongst other places. And there is a network of mass graves of people
who could not follow these people, the Khmer soldiers, anymore because they were exhausted. The question might be put as to whether a person who had been director of S21 could think of defecting from his camp in a way that would make him safe still. You have mentioned the chaos that existed in 1979. The stability came soon after, at least from a peacekeeping standpoint. It might be thought that the accused saw no personal interest in defecting in light of the role that he had played for 4 years previous to that, which means that he felt more bound to stay, even though he knew that he was a movement rather than a state where physical elimination continued. Proof of this is that when he defected, he was the victim of an assassination attempt which succeeded in killing his wife. This confirms that there was some risk to his person. I think going further than that would be speculation. I am of the opinion that, and I know that comparisons are dangerous, there is no head of an SS extermination camp who joined the Allies. The majority tried to flee or to become anonymous, primarily in Latin America. So, if you have a curriculum vitae, as it were, of Duch in 1979, I do not think it is what you would be inclined to join the regime or the authorities that have overthrown the regime that you served. Mr. President, if you grant me leave, I should like to put a last question.
The President, you may proceed, but please be mindful of your time allocated because we would like to make sure that we finish hearing his testimony this afternoon, and I hope you would also help the chamber to suit this purpose.
Prosecutor, I am afraid we did not hear what you said, Mr. President. So, as there was no translation, I do not know whether I am allowed to put the question or not.
The President, of course, you are allowed to put your last question, but please remind that the time allocated to you have been fully used, and we wish to remind you again that if the prosecution has used more than the time allocated to you, then the other parties would wish to have their time doubled as well. And the chamber is of the opinion that if this system keeps going, then we would probably not be able to finish hearing the testimony of Mr. Jinnah this afternoon. And we do not wish to have the session in relation to this testimony to any time after this Pchumban festival. So could you please try to limit to the time allocated for you and that use it wisely. Thank you.
Prosecutor, thank you. So this is my last question. Mr. Jinnah, on the 6th of August 2009, Judge Cartwright quoted David Chandler in a question she was putting to him, and she said, I am quoting from your book, Mr. Chandler. S21 was probably the most efficient institution in the country, and given that S21 was protected itself from its real and imagined enemies and the party's real and imagined enemies, S21 was one of the major organs of the party. End of quote. And Judge Cartwright asked whether this was consistent with the emerging picture of S21 in relation to other institutions of the Santebal, and Mr. Chandler replied, yes, indeed. The judge analyzed other, and it was said that having analyzed information from other centers, it was discovered that the same results were not obtained from interrogations of other prisons of the Santebal. The other prisons were not run from the highest levels of the party. With regard to the efficiency of other prisons, it would appear that they were not at all as efficient as S21. Unlike S21, the other centers did not attract the attention of the senior leaders of the country. So, what I would like to know is your response to Mr. Chandler's statement that S21 was one of the most important organs of the party, and the fact that it was in S21 where they had the large number of networks of traitors, thanks to to the actions of Duch and his acolytes. And the people who there were people who were executed as a result of this, but was it not specific to S21 that they collected as many confessions and unearthed all these quote-unquote networks of traitors in democratic Cambodia? Does this not make S21 unique as an institution of that type? Answer. I am disappointed.
Non seulement beaucoup de respect, mais beaucoup d'admiration pour le travail de David Chandler.
I have a lot of respect and admiration for David Chandler's work. Mr. Chandler is a pioneer and a model for us all, but we might disagree on some points. When you say that many networks were discovered, I do not get the feeling that it was S21 that conducted the investigations to unearth these networks. There's no record of that. The people who were taken to S21 had already been suspected or investigated or had already become the victims of jealousy or conflict within a political party such as the one that existed at the time. But upstream, it was not the director or the employees of S21 who conducted the investigations. They are not the ones who justified the decision. It was not their decision. It was the decision of the standing committee to send people to S21. With regard to discovery, well, the confessions are justly famous or infamous in that victims said what they said. These choices made in the confessions were made by Office 870. That is the origin of all. Now, with regard to the end of the quote by David Chandler, I am in strong disagreement at this point. There were many less victims in the other 195 security centers. If that was the case, then why do we have 1,700,000 dead? How come there are so many more dead than the 12,000 dead mentioned in the introductory submission? If the other centers were as inefficient as that. and people did die. Once more, I'd like to say that we should be careful of statistics, especially if they are based on decomposed mortal remains. The security centers have been identified. We know where they are, and we have what we have in Chung Eik around these security centers. So there were executions, mass executions, a great number of them. I do not think we should minimize what happened elsewhere. Although the other security centers were not the last place where senior leaders, national leaders went, there were a sufficient number of intermediate leaders who died in other security centers. Mr. Destmal, thank you, sir. I have no further questions, and I would like to thank the court for granting me more time.
Merci, Monsieur le Président.
Civil Party Lawyer. Thank you, Mr. President. Mr. President, Your Honors. On behalf of my colleagues, I'd like to put a question to Mr. Jenner. We wonder, we heard that you met Mr. Duch when he was detained, and in the record of the case, there is no document attesting to this visit. There is no report on these interviews. So this is the question. In what capacity did you go and visit the accused? When was this, and why was there no report that would enable the parties to these proceedings to find out what the content of your interviews was?
The President, since it is an appropriate time to take the adjournment, the Chamber will take the adjournment for 15 minutes. Any parties who wish to put questions to the expert could do so during the time allocated for them. The court official The court official is now instructed to make any necessary arrangement for the expert to have to take the adjournment also. The greffier, all rise. The President, please be seated. The chamber is back in session. The remaining time of this morning session will be used to hear the testimony of the expert, Mr. Raoul Mak Jena. The court official is now instructed to call the witness. The President, good morning, the expert. Could you please give the court your full name, please?
Je m'appelle Raoul Marc Génard, Monsieur le Président.
My name is Raoul Marc Génard, Mr. President.
How old are you, say the President?
63 ans, Monsieur le Président.
I am 63 years old, Mr. President.
The President, where do you live?
Où se trouve votre lieu de résidence?
En France, Monsieur le Président.
I live in France, Mr. President.
The President, what is your occupation?
Quelle est votre profession?
Je suis consultant en relations internationales.
I am a consultant in international relations, Mr. President.
The President, Mr. Rahul Marchena, what is your religion?
Je ne suis d'aucune confession, Monsieur le Président. Je suis athée.
I am an atheist, Mr. President. I believe in no religion.
The President, according to the report of our greffiers, indicate that you are not related to any parties to the proceedings. Is that correct?
C'est tout à fait exact, Monsieur le Président.
That is totally accurate, Mr. President.
The President, as the expert before the extraordinary chambers in the courts of Cambodia, according to Rule 31.2, the expert is to take an oath according to his or her own religion or belief. Would you wish to take an oath before the chamber now?
Oui, Monsieur le Président.
Yes, Mr. President.
The President, Natasha, could you please arrange the oath for Mr. Raoul Marc Génard?
Au serment et avec donc le témoin expert, Monsieur Raoul Marc Génard.
Bonjour, Monsieur l'expert. Veuillez répéter après moi. Je prête serment d'apporter.
Good morning, sir.
Je prête serment
Please repeat after me.
à la chambre de première instance.
I swear that I will cooperate with the trial chamber faithfully and to the best of my ability.
Je prête serment d'apporter mon concours à la Chambre de première instance, fidèlement, confidentiellement et au mieux de ma compétence.
The President, next we would like to give the floor to Judge Lavergne to seek further clarifications. The floor is yours.
Oui, bonjour Monsieur Génard, je suis donc le juge Lavergne.
Good morning, Mr. Génard. I am Juge Lavergne. I will be asking a few questions of you. It is customary before this chamber, prior to giving you the floor, to put a few questions to demonstrate that you have the qualifications to act as an expert. So I will be looking into your biography, and you will confirm whether or not it is accurate. You have a doctorate in political science, and you have degrees from Belgian and French universities, and unless I am mistaken, you are a doctor of Khmer science and Khmer studies, a diploma which you obtained from INALCO. Is this accurate? You have undertaken various professional activities, a French professor, journalist, advisor to the Belgian government, to the Belgian parliament, diplomatic advisor for the International Forum of NGOs in Cambodia, consultant with the Provisional United Nations Authority in Cambodia, in charge for UNESCO's Culture of Peace in Cambodia, consultant with the European Union on Cambodian political issues. You have also been an international observer during the withdrawal from Cambodia of the Vietnamese Expeditionary Corps. That was in September 1989. You were also an observer in the elections of 1993, 1998, and 2003. You are a member. I'll give the English expression.
Advisor of the Documentation Center of Cambodia, c'est-à-dire membre, si je traduis en français, du comité scientifique des conseillers du centre de
Translate member of a scientific committee of advisors for the Cambodian Documentation Center. Is this still the case? As a matter of fact, this scientific council was created at the initiative of Yale University in order to establish what has become DCCAM today. So this scientific council was disbanded.
Vous avez également exercé des activités de chercheur.
You've also been a researcher for Oxfam on issues dealing with the World Trade Organization. You also worked as a consultant with various parliamentary groups on issues of globalization. So do you wish to add anything to this summary biography that I've just listed? I would also state that you've written various books on Cambodia, one on the creation of Cambodia, another one called Cambodian Chronicles, another book called Keys to Cambodia, and the last one which is called Cambodia, a Media Under Pressure. Do you see anything else that you would like to add to this biography? And perhaps you could also tell us whether you have at any time been, or if you are still, an advisor to the Royal Cambodian government.
J'ai rien à ajouter par rapport.
I have nothing to add to the biographical and bibliographical data, and I confirm that I am a consultant with the Royal Cambodian government, more specifically on issues that deal with foreign relations and border issues, and in fact I wrote a doctoral thesis on the borders of contemporary Cambodia. So we have in the file a consultation, that is the name given to the document, a consultation which was sought by the defense of the accused with reference D82 of the investigation file. In this consultation, the defense had sought to obtain various information on the following points from you. First of all, the ideological inspiration for democratic Kampuchea, the specific features of Cambodian communism, the practice of Ankar, in parentheses, Kampuchea Communist Party, secrecy and terror, chain of command, security apparatus, the role of the People's Republic of China, and the international legitimacy of democratic Kampuchea and Son Sen. These were the questions around which the defense had asked you to give some details. Well, I will first give you the floor, and then we will be asking some questions.
Merci, Monsieur le Juge.
Well, thank you,
Monsieur le Président,
Judge Lavergne. Mr. President, distinguished members of this trial chamber, it is with a great deal of emotion that I speak before you. Emotion because I'm aware of the historical nature of this trial. Emotion because we are not here looking solely at historical facts, but because we are dealing with lives and mainly deaths, incalculable suffering, and in total the occurrence, once again, of barbarity, while those of my generation were steeped in the never again, stated by Rachel Cross, the British prosecutor, in his final arguments before the Nuremberg Tribunal. Please also allow me, before anything else, to pay tribute to the victims of democratic Kampuchea and to express my sympathy and compassion to the survivors. Right-wing totalitarianism was tried in Nuremberg and Tokyo. Totalitarianism invoking left-wing values had until now never been put to trial, and thus this is the first and probably the only tribunal where the crimes of a form of totalitarianism applied on behalf of the people has been applied. Now, I am not one who will confuse ideologies and puts them back to back. The roots of communism have nothing in common with those of fascism or militarism, and when ideologies choose to force and to compel rather than to convince, they find themselves along similar lines and a common ability to destroy the lives of individuals and the dignity that is contained in every human being. Therefore, what we are doing here and now is judging what I would call Pol Potism and to verify in what way the implementation of this Cambodian variant of communist ideology has led to a barbarity that justifies the qualifications of crimes against humanity and grave violations of Geneva Convention. To judge, first and foremost, but to judge. Is it not first to understand and to explain? Is it not the primary virtue of justice to explain behaviors in order to offer up to society reasons and means in order to avoid that they be repeated? That never has there been a better opportunity than today to see the relevant application of the terrible sentence of Primo Levi, a survivor from Auschwitz. Those who ignore the past are condemned to re-experience it. And as François Bizot stated here as well, we need to understand and to try to understand, but trying to understand does not mean to forgive. So this is my position. Mr. President, I am being requested to bear testimony as an expert from the defense, but I would like to specify that I am not here to speak in defense of a system for which I have nothing but horror. I am here, and this is what I will try to do. I am here to attempt to explain a system that leads to barbary, a system which I would like to explain according to the terms of the ruling of your chamber, the theoretical and practical foundation of the regime established by the Democratic Kampuchea regime, and specified the measure in which the authorities of the time made use of the terror that they had implemented in order to justify the ideology and to determine its impact on human behavior.
I agreed at the request of the defense to come before you on two conditions: that I would be free to express myself as I wished, and that I could meet the accused. I do not think I need to say that I speak freely, but it seems necessary for me to emphasize the full cooperation of the accused, who answered all the questions I put to him when I had interviews with him over a span of 6 months. I hope my explanations will contribute to understand what Van Nat, one of the victims of Duch, acknowledged before you. That is, how an executioner is, in a certain way, also a victim of the system that he serves. A system, because you will agree that the idea is to judge this system and those who implemented it. It is not possible not to know that in Cambodia we were faced of a criminal conspiracy of a small group of men and women to enslave a whole people to an organization which was determined to impose the most total form of alienation that a human society has ever suffered. This conspiracy arose from the espousal by this small group, which provided the future leaders of Cambodia, of an ideology which, in the name of emancipation of people, became one of the most implacable forms of enslavement. With reference to ideology, it must be said that this is the first point I wish to raise. With regard to the ideological background which inspired Angkar at the time, the major reference for the Communist Party of Kampuchea was 1976, 1917, and the events that followed. Pol Pot, in his famous article of 1952 entitled Monarchy or Democracy, which was published in Khmer Niset, the Khmer Student, which is the bulletin of the Khmer students in Paris, signed original Khmers, makes no reference to the Vietnamese Revolution of 1945 or the Chinese Revolution of 1949. It mentions 1917. I agree with Steve Heder in his conviction that the prime source of Cambodian communism a la Pol Pot was the Bolshevik Revolution. I do not ignore the role that Vietnamese communists played in the ideological training and military training of the Cambodian communists. I do not wish to minimize the importance of the Chinese model in the agrarian policy of Kampuchea, apart from a degree of collectivization and a dismantling of rural families which was never attained in China. It cannot be gainsaid that with regard to the political organization and in particular the organization of the Communist Party, including its rules and practices in security, the basis is Bolshevik.
The small group which later on formed the leaders of Democratic Kampuchea were mostly people of the Marxist circles of the Khmer students in Paris, a discussion group that was formed in 1951. Several of them were at the time members of the French Communist Party, and we know, it is common knowledge, of all the communist parties which were active in the Western countries. The PCF, or the French Communist Party, was the most unconditionally faithful to the policies that were decided in Moscow. It was most faithful to Stalin, and at the time, 1/4 of the French electorate trusted it. The members of the circle were participants in university classes of the new university of the PCF, and faithful readers of brochures of this party and the newspaper L'Humanité, which was an organ of the PCF at the time. There was a PCF cell in the Indochina house of the university residential area, which was where students lived. It had 9 Cambodians. When the Maison du Cambodge, or Cambodia House, was established, a similar cell was organized. Cambodians who lived in town, like Pol Pot, belonged to the communist cell of their neighborhood. The training courses organized by the PCF contained the history of the establishment of this party, which arose from the will of a majority of socialists to adhere to the Third International, the Comintern. That such adhesion or membership required the respect of 21 conditions set forth by Lenin himself, and of these 21 conditions, there was the obligation to apply within the party iron discipline, to submit the press and all publishing services entirely to the Central Committee of the party, to do away with reformists and centrists, to set up a clandestine organization with the practice of secrecy that is required. The 12th condition was the Communist Party cannot fulfill its role if it is not organized in the most centralized manner, if iron discipline, which resembles military discipline, is admitted, and if its organization, the central organization or central organ with broad powers, exercises unchallenged authority and receives the unanimous trust of militants. Condition number 13, communist parties in countries where communists are active, legal militants, must carry out periodic purges of their organizations so that the petit bourgeois elements can be removed. It is therefore important to note that the Cambodian students who joined the French Communist Party were trained to believe that a communist party must have iron discipline and eliminate opponents and people who were lukewarm. Interviews of members who are still alive, that is, members of this Marxist circle of Khmer students in Paris, are full of information with regard to the question that we have before us. We learn that of books written by Marx, Lenin, Stalin, and Mao, 2 books were carefully studied and were the subject of lively debate. Lenin's book, The State and the Revolution, and Stalin's book, The Principles of Leninism. In the first book, that is Lenin's book, Lenin says that it is possible to carry out a revolution even in the absence of a proletariat if the people, as a majority, are suffering from exploitation and oppression and rise up violently to destroy the old society and establish a new one. This book also contains the idea, which was echoed by Mao, that once overthrown, the exploiting classes remains stronger than the class that has overthrown it for a long time, and that the victory of popular forces
does not mean that bourgeois forces cease to be a threat. The second book by Stalin stands out because, according to the accused's words himself, as from 1970, all new members of the Communist Party of Kampuchea had to read this brochure for this publication. In Chapter 7 of the book, which is devoted to the party, the well-known conditions of Lenin, the relationship between the USSR and the Communist parties had not changed. The description of the role of the party deserves some further examination in order to understand what was inculcated into the future leaders of democratic Kampuchea. The petty party is the vanguard of the proletariat that it must guide and conduct and lead. The party is an organized whole. Its task is to organize and support the proletariat. It is the instrument of the dictatorship of the proletariat. The party must be as centralized as possible, and it must be governed by iron discipline, which must be close to military discipline. And Stalin quoted Lenin when he said that the center of the party is an organization or an organ which has high authority with broad powers. Stalin, citing Lenin on several occasions, iron discipline requires the refusal of internecine warfare within the party, unfailing obedience, the purging of opportunistic and reformist elements. It is clearly stated that the latter cannot be overcome through ideological debate, so they must be purged. Lenin says they should even exclude excellent communists if they are likely to hesitate. This is the model of the Communist Party, which was taught by the PCF, the French Communist Party, to the members of the Marxist Circle of Khmer students. This circle included not only Pol Pot, Ieng Sari, Ieng Tirit, Hu Yun, Thieu Sampan, Meiman, Thuen Mum, but for the purposes of this trial, most important, there was Son Sen. In 1954, Son Sen was a member of the PCF cell in the Maison du Cambodge. He became member of the Standing Committee of the Central Committee, Vice Prime Minister and Minister of Defense of Democratic Kampuchea, Commander-in-Chief of the Chief of Staff, and in this capacity, the commander of all the armed forces and the political police, the Santebal. Son Sen, who was a member of the Supreme National Council, which institution was established by the peace agreements to represent legitimacy and sovereignty of Cambodia during the transition period. Son Sen was the mentor of the accused. He was the person who trained him and protected him before 1975 and after 1979. He was his immediate superior during the years for which the accused is being tried today. Son Sen was in France from 1950 to 1956. He participated in the activities of the Marxist Circle of Khmer students. As I said, he was a member of the French Communist Party. Like his comrades, he was involved in the debates that exercised the communist world at the time. It is useful for this trial to remember what happened between 1950 and 1956 to the communist world. In the Soviet Empire, they had the trials of 1936 to 1939 in Moscow, which had condemned to death several famous architects of the 1917 revolution and proved that no one is beyond the reach of party justice. And when Son Sen and the others were initiated into Soviet communism, in Eastern Europe, a series of well-publicized trials involving real authentic revolutionaries with heroic past. At the end of 1949, there were trials in Budapest and Sofia, where dozens of communist leaders were charged, tortured, and condemned to death. In November 1952, there was the Prague trial of Rudolf Slansky, the Secretary General of the Czech Communist Party from 1945, and several other leaders and members of government, including Arthur London, who left his testimony in the form of a book called The Confession. Many were heroes of the fight against fascism in the international brigades in Spain and in the resistance during the Second World War. This was the most important trial because of the people who were being tried, but also because of the reverberations that the Soviets wished to vest it with. The idea was to prove that during this Cold War there was iron discipline. Iron discipline was required, purges were required in the party, and that no one, regardless of his or her past and merits, was free or was safe. This was the message that was sent out to all communists in the world so that they could close ranks and unfailingly follow the Soviet Party. In France, the Humanité newspaper recorded or reported on all stages of this trial and always called for revolutionary vigilance. In Paris, the French Communist Party did not want to be left behind in respect of its Soviet model, and from September to December 1952, it organized its own trials. It tried two people, Charles Tillon and André Marty. In Paris, there was no torture, there was no execution, but these people suffered or went through the same process of degradation as that which was implemented in Eastern Europe. The humiliation was worsened by the solitude in which the party placed these people by reporting them to the comrades. The negation of the person presumed guilty whose militant life was challenged, calumny with accusations of spying, treason, work to undermine the party and the people, dialectic confinement, which meant that either the accused acknowledged his wrongs, denies years of devotion, accused himself, and serves the party, or he refused and he served the class enemy. It is this process of degradation which was at the heart of the methods that were employed in S21. We realize that whilst they were in France, those who became the principal leaders of democratic Kampuchea received political education whose principal characteristic was to be largely based on the Soviet model and the practices of Stalinism. As has been already indicated, however, one of those Cambodian students is one of those who became the mentor, the protector, and the immediate superior of the accused. While the Soviet model constitutes irrefutably the most important ideological source of democratic Kampuchea, we should bear in mind the contribution of the Vietnamese communists. The theoretical work of Ho Chi Minh was added to other sources of Marxism-Leninism, but we should bear in mind that Ho Chi Minh was present in France in 1920 at the Congress of Tours, where 21 conditions were examined and discussed for a long time. The Vietnamese ideological inspiration is hardly distinguished from Soviet inspiration. The Vietnamese source reproduces the Soviet source. It is not original, but it is important to mention it because it is to this Vietnamese source that, as from 1950, Nuon Chea will be trained. Nuon Chea from 1977 in September would be the direct superior of the defendant. From 1952 to 1955, Nuon Chea spent 3 years in North Vietnam for intensive political training. I would now like to examine the 3 sources of terror as a method of government. In my view, the first source of terror is a culture of violence. It was mentioned earlier that I was head of the UNESCO program of Culture of Peace in Cambodia, and I was led to study violence in Cambodian society as a product of the tragic years of the 70s. But it must be admitted that this violence is not new. It is a historical fact that political violence is part and parcel of the Cambodian society's fabric. Even if they agree to limit themselves, even if we agree to limit ourselves to the period which began with the independence of the country in 1953, the study is edifying. First the Democratic Party and then the Communist Party were successively the subject of systematic suppression. Political leaders, opposition journalists were assassinated. Members of the opposition were shot, and the pictures of their execution were introduced ad nauseam in film news. At the beginning of the 50s, the accused was too young to remember the violence against persons which contributed to the destruction of the Democratic Party. But the killing of Ngoc Bopan, the editor of the leftist newspaper Prachir Chon, the attack and public humiliation of Khieu Samphan, who was then the editor of the newspaper The Observer in July 1960, the arrest in the same year of all the writers of the left-wing press who were tortured, as we learned after their liberalization, the closing down of opposition newspapers, the assassination of the Secretary General of the Communist Party in February 1962, victims of police brutality. In 1963, the filmed execution with details of Preap-In. In 1964 are acts of violence which marked Cambodian youth of the 60s. At the time, the accused was 20 years old. Under Sihanouk, it was enough to publish a poem of the 17th century inviting civil servants not to ill-treat people in order to be imprisoned. With the beginning of the American war in Vietnam, violence became more widespread. It came from the outside, but also within the country. The Cambodian villages of various provinces bordering Vietnam were attacked by South Vietnamese troops supervised by American officers, causing the death of hundreds of persons. From February 1969, with the operation known as Menu, B-52 bombers of the U.S. Air Force caused thousands of civilian victims to lose their lives. The violence from the Cambodian authorities did not reduce over time. The peasant revolt of Sam Laut in 1967-1968, which was adopted for political reasons by the Communist Party of Kampuchea, was the subject of unprecedented repression. Villages bombed, peasants massacred, prisoners and their wives tortured. They were capital executions of a nameless barbarity. Violence increased, if that were still possible, with the plunging of the country into war, which followed the 1970 pro-American coup d'etat. The protests of enemies of the government of the coup d'etat were savagely suppressed, and there were hundreds of dead in the 4 provinces where they took place. Civilians were slaughtered on the sole basis of their ethnic origin. It was a pogrom, a massacre of Vietnamese people whose scale aroused international interest at one point. The blind violence of American bombings of villages extended to the entire country. It seems important
to recall here that we know since President Clinton ordered the declassification of documents pertaining to American bombings in Cambodia, that 2,759,941 tons of bombs were dropped on Cambodia from October the 4th, 1965 to August 15th, 1973. On 230,516 sorties. In comparison, 160,000 of bombs were dropped on Japan from 1942 to 1945, and 1,350,000 tons were dropped on Germany from 1940 to 1945. In all the history of humanity, no other country has been bombed as much as Cambodia. Cities like Memot and Snol were razed. The University of Takeo Kampot was reduced to rubble. Thousands of kilometers of canals and rice fields were destroyed. Defoliants dropped by the American Army poisoned 150,000 hectares of forests and rubber plantations. During the 1970 to 1975 war, the fighting was accompanied by extreme acts of violence in both camps. There was systematic torture, beheadings, livers being torn out, as if from now on everything was allowed, and there was a total denial of human dignity. Cambodia plunged into violence and took flame, and the behavior of everyone concerned has been affected, deeply affected. The violent settlement of disputes became the rule, and physical liquidation became the only form of resolving conflict.
The second source of terror's method of government was political violence as applied under the leadership of Democratic Kampuchea. As I stated before, several leaders of Democratic Kampuchea had been trained, particularly in France, to the Bolshevik and Stalinist practices of communism. We've seen what the principles of Lenin were with regard to party functioning, iron discipline, elimination of doubtful elements, to seek the enemy within the party, and is in fact the title of a Cominform resolution of November 1949, a directive written by Rakosi, General Secretary of the Hungarian Communist Party, who was one of the instigators of trials in Eastern Europe, was translated into a formula about which I wish to draw your attention. It is preferable to arrest innocents than to run the risk of leaving guilty persons go free. And this is a sentence which was published by L'Humanité, and this is a sentence which we found in the Democratic Kampuchea in two slogans. It is better to arrest 10 persons wrongly than to liberate one or by mistake, or it is better to kill an innocent person than to keep an enemy alive. You will have noted the semantic slip, which makes it possible to go from the deprivation of freedom to physical elimination, because, as Arthur Koestler recalled in his book Zero and Infinity, he, who was a member of the German Communist Party from 31 to 38 and one of the Comintern agents, he said, to regulate a divergence of opinion, we know only one argument: death. The leadership of the Democratic Kampuchea Communist Party applied literally the Soviet concept of the party as most of its members had observed from Paris. One, the Communist Party of Democratic Kampuchea is under the leadership of a center with extensive or broad powers. It is the equivalent of a central committee made up of 7 persons and 2 substitutes. This is the small group which concentrates the gist of power and Sun Sen was a member of it. This standing committee, which the members carry out their functions in a building which has a code name of 870, carry out all the responsibility conferred by the party upon the Central Committee in all fields: organization of the party, administration, the economy, defense, security. The standing committee exercises absolute authority on the apparatus of state as well as on the apparatus of the party, which in fact are fully merged. Two, the party practices an iron discipline, which is expressed through the elimination of the internal enemies, an elimination which is not only a political one, but also a physical one, an elimination which is expressed by one word: to smash. Smash, which means, according to explanations supplied by the accused himself, to secretly arrest a person, to question that person using torture, then to secretly execute the person. In one of the working logs of S21 dated 1976, which some have called a manual for torture regarding the technique of extracting confessions, it is stated that the objective is to obtain confessions that are as detailed as possible. Arthur London, who survived the Prague trial, recalls in his book The Confession, published in 1968, the statement of his torture. What counts is the confession. In one of the interviews I had with the accused regarding his training to be in charge of a security center, he told me, and I quote, "Pol Pot and Sun Sen wanted us to apply the Soviet practice. As in Moscow, Bucharest, Budapest, or Prague, no one was sheltered. Hardly in power, the Communist Party of Kampuchea began to eliminate some of its most prestigious militants. Hu Yun, former Sankum deputy, minister of Grunk, minister of Democratic Kampuchea until he was eliminated. Chuk, veteran of the Isarak movement. Kimias, who was a veteran of Pratichun, one of the founders of the party. Kiomoni, who was an Isarak veteran. Amepo, the most illustrious of veterans, who had taken part in the coup in the royal palace on 9 August 1945, Long Swan, Minister of Agriculture. All were executed between April 75 and December 76. Poitun, Minister of Trade, former collaborator Kyosampam in the paper Observer, Kyupan, Minister of Public Works. The Sienyan, one of the founders of the Marxist Circle of Paris, Puk Chai, a young left-wing intellectual whom Sihanouk had sentenced to life imprisonment. Tifrol, former teacher and left-wing intellectual, forced into the underground from 67, and Hunim, a former MP of Sankun, Minister of Information, were all executed in turn in the weeks that followed. Even not the first director of S21 was incarcerated and executed on orders of the party. Two members of the government, Von Ved and Konsopal, were executed in 1978 to exercise the leadership, of one of the 197 security centers did not at all shield you from this. The fact that some are still alive today and have not been prosecuted, nevertheless, several score of them have been executed. And for all the cadres of the party, the message was clear: no one was safe. And the fact is that over 80% of S21 victims, in fact, exercise some function within Democratic Kampuchea. And one must perforce observe that some of the victims of S21 might, had they survived, been prosecuted by the extraordinary chambers. 3. The Communist Party of Kampuchea from 1963 operated in the underground. It instituted a secret practice and a partitioning method which became a mode of leadership and management of the party, and from 1975 became a mode of government of the country. In 1970, when FUNK was created, a secrecy conserved the dominant political force within, as well as its leaders who remained anonymous. Throughout the war, apart from Prince Sihanouk, on behalf of whom all of the FUNC forces claimed to be fighting, the personalities that were put forward were former progressive of Sankun, U Nun, and Khieu Sampang. Tens of thousands of people who went into the forest to join FUNC knew only of the rather sympathetic program of the FUNC. They were unaware of the fact that at the heart of the FUNC one found the Communist Party of Kampuchea. They were totally unaware of the specific orientations of the leadership of that party. In 1975, when FUNC became victorious, few knew that since 1973 it was entirely under the control of the Communist Party of Kampuchea, and more specifically by the faction in the party which was most radical under the leadership of Pol Pot. When the latter took control of the country in April 1975, it hid itself, it cloaked itself behind a vague term which in Khmer means organization, and which was the Ankar. It is absolutely necessary to maintain secrecy, Sun Sen said at the time. From liberation, it is secret work that is fundamental. Secret work is fundamental in all that we do, is what Nunchia repeated endlessly. To preserve secrecy and partition the organization of the party, orders are always conveyed on behalf of Ankar. All decisions are taken on behalf of Ankar. They are all implemented in all layers of the country on behalf of Ankar. And this anonymity made it possible to have particular strength. It gave an impression of power, and at the same time created and sustained a feeling of uncertainty and fear in the population. That impression and that feeling quickly spread because it was on behalf of Ankar that the evacuation, the forced evacuation of towns and cities, forced installation in people's cooperatives, elimination of currency, and total reorganization of society were created under the authority of Ankar. Every aspect of everyday life is undertaken under the authority of Ankar. Fear of Ankar when people are called upon to go to a given place and never show up again, and of course when the murmurs about executions began to occur. The Ankar requires total and unconditional loyalty. Any failing must be either confessed or must be reported, and thus delation became, in fact, a constant behavior. Everyone is watching and spying on everyone in a society that is exacerbated, where everyone is becoming the spy of all. And so the circular instructions which were sent out to the cadre of the party, the army security apparatus, total obedience to Ankar was identical with that required from communist parties in the Soviet Empire. The comparison between certain slogans of democratic Kampuchea and formulas used during Stalinist show trials is striking. Arthur London recalled that his torturers constantly repeated, "You must trust the party, and you must let the party guide you." And an echo of this is heard amongst the torturers of S-21 when they write in the manual that was already mentioned, and I quote, "What is most important is to believe absolutely in the party, or further, to believe in the party, to respect the instructions of the party, absolutely and unconditionally." Third and last source of terror as a method of government, the specificity of Pol Pot's communism. The communism of democratic Kampuchea, which I would call Pol Potism, has a series of specific features which, when they are brought together, will supply a unique interpretation of Marxist doctrine amongst all the interpretations that we have known until that day. That interpretation emphasizes state terrorism that is specific to any totalitarian regime. Pol Polpotism is not internationalist, it is nationalist. The leadership of Democratic Kampuchea vehiculated an expansionist form of nationalism characterized by territorial claims and by irredentist claims. Their statements evoked lost territories and claim that there is a need to reconquer these territories as far as one can find Khmer language writings. And this is the origin of repeated attacks against Vietnam and obsession with the Vietnamese enemy, and obsession which, after the breakdown of diplomatic relations at the end of 1977 and the development of a state of war between the two countries, was to lead to the elimination of tens of thousands of persons with the reasoning that they had a Vietnamese mind in a Khmer body. Polpotism is not democratic. It is a completed oligarchic model. The people of the regime of Democratic Kampuchea never enjoyed popular support. The opposition to Lenol was, in fact, incarnated by Sihanouk, to which the leadership of the Communist Party seemed to be paying heed. And even within the ranks of the Communist Party of Kampuchea, the political line of Pol Pot and of his assistants never was the object of fully expressed support. Prior to 75, as well as after 1975, Cambodian communists in their majority escaped the characteristics of Polpotism. This means that the leadership behaved as in a besieged fortress, with the resulting instructions to chase after enemies of the inside and using terror as a mode of government. The directive of 30 March 1976, called Decision of the Central Committee on Various Issues, tackles at first a question, and I quote, of the annihilation within the ranks and outside of the ranks of the party. Polpotism is autarchic. The will turned into a slogan to count exclusively on your own forces led to a feeling that reinforced the besieged fortress feeling and distrust of all. Polpotism contains a racist dimension. One must protect the purity of the Khmer race is one of the slogans most often repeated by the highest leaders of Democratic Kampuchea. This determination was expressed in the physical elimination of various human groups that were oddly qualified as a Sino-Khmer, Viet Khmer, Cham Khmer, etc. It led also to radicalization of unprecedented radicalism. After the forced evacuation of towns and successive deportation of entire populations, collectivization of agricultural lands, abolition of currency and of trade, no goods, no house, no land belonged to a single individual anymore. Dispossession was total, to the extent even that it refused that persons would be free to use their own identity, time, choice of relations, and even conferred upon cadres of the party the choice of the man and woman who would become a couple, and the choice of the intimate moments that they could enjoy together. In the cooperatives where Cambodians are regrouped, in fact, often it is the case that they don't even own the utensils which they use in order to feed themselves. It has never, ever been the case in the history of humanity that collectivization has gone so far as it did under Democratic Kampuchea. Never in human history has the negation of human dignity been carried so far. Never has it been the case that a political regime had imposed such a dispossession of self, not only upon a given category of individual, but upon an entire population including those serving the regime. Pol Potism expresses the determination to go to the new society in a single leap with no transitional steps. The basic purpose was to do better than Lenin and Stalin, to go further than the Chinese and the Vietnamese in the creation of the society that they want. The most radical transformations were implemented with an intensity that knows no equal, without the slightest consideration for human cost. Lastly, Pol Potism expresses, as rarely has been the case in the history of humankind, the most total scorn for human beings, as could be witnessed and testified to by slogans such as "Our heart bears neither feeling nor a spirit of tolerance," or "Whoever protests is an enemy, and whoever is opposed or resists is a cadaver." Mr. President, distinguished members of this trial chamber, the accused states that he was both the helper and the prisoner of the system. Upon analysis, I must say that the situation which he describes is reality. A great anti-fascist intellectual, one of the great French writers of the 20th century, who was also a resistant against Francoism and Nazism, stated, and I quote, "We refused what the beast wanted of us, and we want to return to the human wherever we have found what crushes it." And it found itself at the highest level. We found at the highest level of the leadership of Cambodia men and women who made it possible that the beast within us could have free rein to express itself. They are the ones who opened the doors of barbarity, and it is they who should shoulder first and foremost the greatest responsibility. Those who followed by the subservience or zeal, nevertheless, are not innocent. And I would like to conclude with this question, Mr. President. Who can, in conscience, faced with the dilemma of having to kill in order to avoid being killed, can assert and affirm that he will make the ultimate sacrifice? Thank you.
The President, the Chamber is very grateful to Mr. Raoul Marc Chenard for your comprehensive testimony. However, since it is already appropriate time to take the adjournment for lunch, although we have not yet completely heard the testimony of yours, and that parties to the proceedings will be putting questions to you, so the Chamber would like to request that you come back to the courtroom after lunch break when the session resumes at 1:30 p.m. The court is now adjourned for lunch break. Court official is now instructed to assist the expert during lunch, and the security personnel are advised to take the accused back to the waiting room. The greffier, all rise.
Au centre de détention, la greffière, veuillez vous lever.